Okay, the next group of people are going to testify, which I think is the last group for these bills. Kiana Avalon, David Velez from the Rhode Island Interfaith Coalition, Andrew Mueller, and we haven't got, how about Bella Robinson? Is she here? Okay. And Claire Hardy.
Thank you, Chair and committee members. Should I testify really quickly for all of the bills or just LEOBOR?
Yeah.
Might as well do it, right? Thank you for having me. David Valise, Director, Rhode Island Interfaith Coalition to Reduce Poverty. We are a coalition of faith leaders throughout Rhode Island that are dedicated to fighting inequality and poverty. I'm just going to run through the numbers and just give a quick sentence. We are here to support several bills. First, 5149. We do believe in eliminated life without parole. As Rabbi Goldwasser just mentioned, we think it's immoral to determine that someone has no chance of redemption, a quality that is rooted in a lot of our faith traditions. We also support 5361, a bill that again will change the definition of a year sentence to 364 days. It keeps families together, and it would end it would disproportionate impact on immigrant communities, and we believe in not criminalizing immigration. We support 5563, bail reform. Again, this disproportionately impacts poor communities and communities of color, something that we believe is a staple of justice. We believe in repealing LEOBOR. If not, we also at least believe in adjusting it. I think we've heard a lot of testimony tonight, but I will just say that without oversight and without accountability, it creates more distance and more distrust between community and law enforcement, which perpetuates a system of violence and oppression of these communities, especially communities of color and poor communities. And it's about holding people accountable. We also support ending solitary confinement, 6161. We believe it's cruel punishment. If you haven't had a chance, there's somebody will remember what show I'm thinking about, but they just had an episode on solitary confinement. I suggest you go check it out on HBO. And we support ending life without parole. I already mentioned. Just wanted to thank everyone who's coming. I am not an expert. I will say I've been a social justice organizer for over 25 years, so I come to this as a community member that has not only experienced police harassment, not only experienced friends and families going to prison, but as someone who also believes in love and justice. Some of these issues are very complex, but I will ask us to think that if the system is broken and if the system is corrupt, then those involved in the system deserve a second look and a second chance. Thank you very much.
Thank you.
Good evening. Can you hear me? Hi, my name is Bella Robinson. I am here in opposition to one bill and support of 15. I'm not going to list them all. I'm sure y'all are grateful. At Coyote, Rhode Island, we are a group of sex workers, survivors, and marginalized people that have been incarcerated. We are opposing H5299. Regardless what we think about guns, we think it's insane to extend LEOBOR to campus police. The other bills we're here to support is H5567, H5686, H6164, and H6163. And obviously I don't have time to talk to you about all of them, but I do want to point out that in the report that we emailed all of you months ago, we have 55 incidents of police engaging in sexual conduct with women during vice stings, and that's just what's in the charging documents that they wrote. We know from street-based outreach that this has been going on. My first arrest, I'm 58, I was 18. I wouldn't date a police officer who arrested me and sealed my fate, and I've been a sex worker for 40 years now. I often have to make quick, split safety decisions without a badge and a gun. I served 3 years and 5 years at Lowell Correctional in Florida, which is the biggest women's prison in the country. And in 2020, DOJ wrote a report that they have violated our rights by allowing the sexual assaults to occur for decades. And they even documented the retaliation while they were there investigating. And guess what? Nothing's been done. We know this is taking place in every jail and prison in the country. This is nothing new. We're not saying all law enforcement officers are bad, but we don't feel putting a Band-Aid on this is going to fix. And even when I look at Maryland, which is the first state that created LEOBOR, 29 states say this is dangerous. We've had a sexual assault bill in committees for 4 years with no one opposing it, just asking to stop correctional officers, probation officers, and police to stop raping women and children. With that, it was very offensive and traumatic for me to have to listen to how long you can be suspended, how many times for not having the right uniform. Really? You work at McDonald's, they'll fire you too if you don't have the right uniform. And thank you for listening to me, and I'll be glad to take any questions.
Any questions? Thank you. Yes.
Actually, I just signed up in support of this bill, but I wanted to testify on 2 bills that actually haven't been even introduced yet, so I'm not sure if you want me to
If you
testify.
want to hang on for a minute.
Yeah, because it's different bills.
Okay, thanks.
All right.
All right.
If I can just say, last week tonight, John Oliver. That's the show. Thank you.
And Claire Hardy didn't answer?
No, that's me.
Oh, that's, oh, okay, there you go.
Yeah, I just want to testify on different bills.
Well, that concludes testimony on the LEOBOR bills, which are H6181, 5567, 6200, and 5888. And Representative Felix, we're going to put your bills in play. I'll start with the first bill on the calendar that you sponsored, which is House Bill 5361. And then, Doc, we're going to put your bill in play? Yeah.
That'll be fine.
And that's an act related to criminal offenses, general provisions. It further defines felony, misdemeanor, and petty misdemeanor. The next one, oh, you want to testify on that? Okay. Yeah, let's put them all in play. 5563, also sponsored by Representative Felix, and it's an act related to bail and recognizance. It provides, or prohibits rather, the court from setting cash or surety bail on any misdemeanor offense, but permits the court to set reasonable non-monetary conditions of bail to assure the defendant's presence in court is required and to protect the community. The next bill is House Bill 5685. It's an act related to criminal procedure, bail, and recognizance. It requires the clerk of the court to return any bail money posted to the defendant or the person who provided the bail money at the time of judgment of the case, and that the money shall not be used for payment of costs, fines, or restitution, or any other assessment. The next is 5697. It's another act related to criminal procedure, identification, and apprehension of criminals. It mandates that the clerk of the district court automatically also seal individual counts of criminal complaints upon dismissal pursuant to Rule 48A for the rules of criminal procedure for the district court. And I believe the last two are 6161, establishes the Restrictive Housing Oversight Committee for the purposes of monitoring the use of restrictive housing, which is solitary confinement, as well as disciplinary and administrative confinement at the Department of Corrections. And I believe the last one has already been put in play by you previously. That's the, yep, that's 6180. And I think that's it.
I'll call it the Leo show for House
The Leo
Judiciary.
Show, yeah.
I like it.
So I'll just make a couple of comments on a few of the bills. I won't go into details for all since, Mr. Chairman, you already gave a brief description on them. But in regards to House Bill, I'll begin with the bail bills. House Bill 5563. So this would release individuals accused of misdemeanor crimes without bail, but on their own recognizance. I should note that there is a sub-A for this bill, which would amend the language to match Senator Quesada's bill 375, and I have Mike DeLoro to serve as expert witness on this testimony, so he will go into details about these bills. I understand the Rhode Island Coalition Against Domestic Violence would like to see specific amendments to the bill to ensure the safety of survivors, which is something that I definitely understand. So I would be more than happy to work with them and anyone else in this room or at home who would like to work with me to amend this bill and make it a reality, just make it a reality for ensuring that it's safe for all. In regards to 5685, which mandates the return of bail, again, Mike will provide some expert testimony on that as well. But this would require the clerk of the courts to return any bail money that has been posted by the defendant or their loved ones. But the bill wouldn't change the law regarding any forfeiture, changing conditions of bail, or increasing the amount of bail, and so on. For example, if a person fails to appear to court, the court would still have the power to forfeit an appropriate amount of the bail money posted. They could increase the amount of bail, etc. So passing this bill would straighten the constitutional principles for the purpose of bail to ensure that defendants do appear before court. Mike and the Judiciary, Chris Boyle, have worked on a sub-A language for this bill, which has been submitted, and it's in the documents for you all to see. But Mike will also go into details for that. And then 5361, it provides clarity between felony misdemeanor and petty misdemeanor. And the clarification in this bill seeks to address the problem that was part of the package from the Governor's Justice Reinvestment Commission in 2017 that unfortunately failed the House back then. So we hope that with these changes, we can go back to making those changes that the Governor's Commission, the Justice Reinvestment Commission, had made. And the legislation may help to reduce the disparities in the criminal legal system as individuals who are charged with similar offenses will be subject to more consistent punishment. Regarding 5697, I think we all get that bill, automatic sealing. So I'll go into 6161, which reforms the use of solitary confinement. This bill is an important bill for a number of reasons. It's important for individuals who are currently or have previously been subject to the use of solitary confinement or administrative confinement, depending on the terms that you want to use. The Act provides for crucial protections for these individuals, including limiting the amount of time that they can be held in solitary and a review process to ensure that they are not subject to an excessive punishment. The Act is also important for prison staff and administrators. By establishing clear limits on the use of solitary confinement, the Act will help to ensure that prison staff is not put in the difficult position of deciding who should be in solitary. The Act is also important for the broader community because the use of solitary confinement has been shown, according to research, to have negative effects on the mental health and can contribute to recidivism rates. So by limiting the use of solitary confinement, the Act promotes public safety by helping to ensure that individuals can successfully reintegrate into society after having served their time. Regarding the last bill, and I also have Andrew who will be testifying as an expert, the legislation provides for free communication services and in-person contact visits for inmates. As written currently, the legislation also calls for juveniles in a residential placement or detention centers for their calls to be free. I have spoken with DCYF officials who have already informed me they are already free, so my goal is to amend the legislation to remove that language from the bill so that we can ensure that it's consistent with what's happening right now. And with that, Mr. Chairman, I have a bunch of expert testimony witnesses if you want me to call them or if you want to call them.
I'm going to put Dr. Corvasi's bill in play, and then I'm going to ask you to round up, you could do it now, round up your experts and bring them in 3 at a time. Okay?
Okay, Mr. Chairman?
Yes.
All right, thank you very much. I want to put 5209 into play. I had a much longer speech, but because of the lateness of the hour and I want people to have a conversation, I want people to get an opportunity to speak on all the bills, of course. I'll make my comments brief. Having been on this committee for a number of years and been in the State House a number of years, I find that sometimes criminal justice reform bills can sometimes be double-edged swords. Sometimes they help one segment of the population at the expense of another. So I'm very circumspect when it comes to many different types of criminal justice reform bills. However, I have my name on this one. And the reason why I have my name on this one is last year I got a very compelling email from a constituent, and I followed it through, and I think there's a great deal of merit to the necessity for giving individuals who have been convicted a second chance, as long as we have appropriate parameters in place. That is what this bill, in essence, does, and at the appropriate time, Mr. Chairman, I'd like the individual to come up and testify because I think his personal testimony is extremely compelling and will convince this committee that we should do something with regard to this bill. And there's a caveat to this. I had a conversation, believe it or not, with Steve Brown today. It was very brief. It was unofficial, but I read his testimony, and his testimony is neutral on the bill, because he's concerned, and it was a legitimate concern, that perhaps this bill may fly in the face of other bills that are trying to do the same thing, but with different segments of the population. So at the appropriate time, Mr. Chairman, I'd like my constituent to come up and testify, and I would also, with your permission, through you, direct our legal counsel to perhaps contact the ACLU and take a look at the bill, at the statutes that Steve Brown feels may be in conflict or may be complementary to what I'm trying to do, so we can have something clean to go forward.
It looks like you got somebody pretty tired back there.
Well,
that wants to-
the gentleman,
Yes,
what?
come on up.
that actually is my constituent, Mr. Candelaff. Absolutely. Through the chair, yes.
Yeah, come on up.
John, thank you for coming tonight.
Thank you.
And thank you for waiting, by the way. And you now see how the sausage is made.
I greatly appreciate the committee's time for hearing this, and Dr. Covesi for sitting and talking with me. My name is John Candelaff. I am a father, a husband, a student, a college graduate, a volunteer, and a neighbor, a Rhode Islander, and I'm also a felon. In February of 2020, during a child drop-off, I experienced a major depressive episode. I made the wrong choice. Thankfully, no one was hurt, but I knew within minutes after it occurred something was wrong. I called my doctor. I went on depression medication. 3 days after that incident and sought treatment. At the end of the week, I was arrested and charged. I pled nolo to the charges in May 2021. I chose to move forward in a positive direction, checking myself into Butler Hospital, going to therapy, changing my way of thinking, even before being put in front of a judge, accepting responsibility for my mistakes. I lost my job of 5 years at Citizens Bank as a result of the arrest. Even though the charges had nothing to do with my performance or anything to do with my work, I applied for positions and was offered jobs in writing at Coastal One, Fairway Mortgage, Granite Telecommunications, even the City of Providence. I was honest with all these employers about my history, but all withdrew their offers once my background check came back. I hold a bachelor's degree from Eastern Nazarene College in Quincy, Massachusetts in business management. I'm currently completing my HR certification at Bryant University. The only barrier to a well-paying position is my conviction, which has nothing to do with my abilities or qualifications. My probation is up in 2026 in the state of Rhode Island. I am not eligible for expungement under the current law. According to expungement eligibility requirements on the Attorney General's website, only certain criminal arrests or convictions, including some misdemeanor crimes and certain nonviolent felonies, may be eligible for expungement. The crime I was charged with is considered violent. Prior to the conviction, I was a volunteer at ICC Church on Plainfield Street in Johnston. I would put together boxes of food for those in need, donate clothes, money, give back to my community. In 2003, I actually won Rhode Island Volunteer of the Month and was featured in the Providence Journal. Giving to my community and others has always been part of who I am. Now, as a family, we struggle financially. And some weeks we go and wait in line for boxes at those same food pantries. According to a 2015 article from American Progress titled "Removing Barriers to Opportunity for Parents with Criminal Records and Their Children," having a parent with a criminal record co-signs the individual, his children or hers, to a life of poverty. I am a proof that this has not changed. My children and my wife did not commit my mistake. There are a total of 20 states that have certificate programs for offenders on probation. Rhode Island currently has the Certificate of Recovery that was passed in the House in 2020. This program is for parolees. Why isn't there one for people on probation or those not eligible for expungement? We also have the Fair Chance Licensing Act passed in 2020, where I could start my own business or take on a trade. As a state, we are okay with felons coming into our private residences, building our homes, office buildings, delivering our goods, owning establishments that serve us. Why does this barrier continue to exist? The majority of jobs open to employ felons are physical or demand money that most of them don't have to start. This is not feasible for someone who also might have a health issue or financial issue. I suffered a heart attack in 2021 at the age of 35 while working at that food pantry. When I was looking for employment, I heard, "You need to get into a different field." Sorry, but why not try something different? You're too much of a liability for our company. Every job offer that would provide hope financially and stability was a retrial of my charges, submitting statements, medical records, court documents, letters of recommendation, anything I had to show that the mistake I made is not who I am. As I received rejection after rejection, I realized I lost more than the money on lawyers' costs and court fees. I lost more than my job. I lost my freedom of choice. Members of the House, I ask you to think about a second chance you were given and remember what that meant to you. I am fortunate to have found employment. My family still has to survive paycheck to paycheck, and I continue to look for extra work because I want to work, and I want to give back, and I want to provide. But there are Rhode Islanders waiting for their chances who do not feel that they have a voice, the option, who live every day on trial for their past mistakes.
Thank you, John.
Thank you for
Next.
your time, Mr. Chairman.
So my name is Amy Candelaff. I am the wife of John Candelaff, who you just heard from.
Could
I
you
am asked-
speak into that microphone a little bit more? Is the red button on?
I think so. Can you hear me now?
If there's no little red light there, then it isn't on.
Yeah, it's red light. There we go.
Okay, that's it.
Sorry. So my name is Amy Candelaff. I am the wife of John Candelaff, who you just heard from. I am asking and pretty much begging you to please hear what he said. He is a very hardworking husband and father of 2 daughters and my son. Before meeting him, I was a believer, like most people in the start, if you are a felon, then they need to pay for what they did. Not ever thinking of the person or the crime. You can say I was kind of stuck in my ways. But after looking at the struggles of my husband and other family members in my family, I believe that everyone deserves a second chance. For example, I work for a company in management. I hired a woman as a temp. They told me everything was okay to move ahead. She was with me for 1 week. She was a great worker and the nicest person. After a week, the temp agency contacted me stating that I had to let her go because of a background. So you see, I've been on both sides and I see both sides. My husband was never in jail, but he's getting punished like someone was in jail. Yes, he made a mistake. Yes, he is owning up to it. But look around you. I bet you, with everyone sitting in this room, we've all made some kind of mistake, some worse than others. No one is perfect. Maybe they've been to jail or maybe they've not. I'm a strong believer in second chances, don't you? My 12-year-old son is sitting in the room. His father has been to jail, so for him to see his father and his stepfather have to fight to find work, what kind of message is that sending him? I am raising him to not ever judge a book by its cover. Basically, the state of Rhode Island is doing just that. My husband has a bachelor's degree in business. He was a single dad at the time when he graduated college. He is currently still going through school to even better his career, but yet here he is struggling to get a job that he can use his degree towards. On paper, he is a rock star, but once they run his background check, they can't hire him because of the record. I am begging you to pass a law stating that gives felons a second chance, especially if they've never been to jail like my husband. Again, we are all human. We all deserve a second chance. Look at it as though they were your children. Wouldn't you want someone to give them a second chance? Let them move on with their mistakes. Let them be free again.
Thank you. Yes, ma'am?
Good evening, everybody. My name is Brenda Felicio. I'm a single mother of 4 children with my second oldest child currently incarcerated. My son has an autism diagnosis, which makes getting a job challenging for him. This bill will help him to obtain employment regardless of the felony charge. This will help him to move forward with his life. He has made mistakes, however, we all deserve second chances. By allowing this bill to pass, it will allow individuals like my son and so many others employment. Their certificate of recovery would allow him to obtain employment even if he fails the background check. Recovery is about second chances and allowing individuals to take control of their lives. People need to provide for their loved ones. The bill will help them to do just that. Second chances are essential to a person's recovery. With this bill passed, it will provide stability for families. Having a loved one with an arrest or felony charge is hard on the family unit. When a person cannot obtain employment and provide for their family, it puts a great strain on the household. Thank you.
Good, Jay.
Sir, when you do you know what the mechanism by which these employers did background checks? Did you produce a BCI for them? I mean, I know you were straight up in the interviews,
Yes.
but in addition to that, did they want to pull a BCI? Did you have you produce something, or did they use a third party?
Most of the employers used a third party and obtained it through the fair credit reporting. Since Rhode Island does report every arrest, it then, if it wasn't disclosed on a statement, so I actually have a written statement I provide to the employer at the point that they say I'm running a background check. I have to supply them the dispositions as well as all that information so they can make that decision. Hey, is this person going to give to my culture, give to my organization what I'm asking of them on that paper? Unfortunately, because most of them see the felony charge, that's a red flag. A felony will keep you out of banking. A felony will be, because it's confidential information. I was working in a banking situation, and even after the charge, I was still working in the banking information.
I totally get that. I see this a lot in my day job, and I'm convinced that the solution to the problem, because this bill, and I so appreciate Chair Corvese for putting it in. This bill really talks about the state and its agencies and what we would do and not do in terms of employment. But for all the private employers that are out there, they're, they use these private third parties, or they have people produce the BCI, and because Rhode Island is essentially wide open when it comes to criminal records, they can see this sort of thing, and they'll draw their conclusions and usually deny employment, and even if employment's been granted, they'll kick somebody off. So I'm going to take this opportunity to use your story to suggest to the committee and anyone else watching that Rhode Island needs to get serious about our disclosure rules for third-party background checks along the lines of Massachusetts, where there's a time limit when an employer can see this sort of thing, depending on who the employer is. Thank you.
Thank you.
Okay, thank you very much. Now, we're not going to be able to finish this one just yet, so we're going to put on your experts.
Mike DeLora wants to come forward,
We're not done yet.
and
We'll
Brandon
finish.
Robinson. as well. Natalia Friedlander. And Shivani can come after.
Not yet. Go ahead, Mike.
Thank you, Chairman Craven and committee members. First, I want to thank Representative Felix for putting in both of these bills. And I'm glad of the opportunity to talk about them at the same time. Both of these bills take a slightly different approach to bail reform. One is just a straight up, and I'm thinking in my mind of Senator Quezada's bill, which I think Representative Felix sub A, this bill will look like that. I don't want to spend a lot of time on that because it's not before you. But what I would direct your attention to is a report that I provided the committee. It was written up in the Providence Journal just a couple of weeks ago. And I provided you a copy of it. The report is entitled "The State of Black Rhode Island." And it's interesting to note that in some of their policy solutions, both Representative Felix and Senator Quezada and their prior attempts at bail reform are mentioned specifically by bill number. The interesting thing I think about that is the negative financial impact that our current bail laws have on persons of color and on that community. Bill number 5685 is the one that I really want to talk to you about. Bill 5685 would end a practice known in other states as bail conversion. Bail conversion is exactly as Representative Felix described it. At the end of the case, if money remains on deposit with the court, that money is automatically received by the state in order to satisfy court costs and restitution. I believe that the time has come to review and eliminate this practice. When I started out that the time for bail reform has come, in this context where we're asking to rid ourselves of bail conversion, we're coming off a year, you've heard me talk about the tremendous progress that was made in 2022. It was my honor to work with any number of criminal justice stakeholders, including the judiciary, Ms. Friedlander, and others, so that the landscape in our courts, I'm here to tell you, has dramatically changed when it comes to the issue of court costs, fees, and assessments. In the past, people actually went to prison when they were unable to pay these fees. That has stopped. And I can tell you that in a much more positive way, indigent people are having their status determined by judges, and pursuant to the legislation that you passed last year, comprehensive legislation that was introduced at the request of the judiciary, the indigent people are no longer required to pay court costs, fees, and assessments. Their status is being determined quickly, effectively, and accurately. So what does this bail conversion bill do? I'll just share with you this anecdote. It was my privilege truly a privilege to serve the state as a public defender for more than 41 years. And I must confess to you that this practice of taking bail money posted by a criminal defendant or the criminal defendant's family or friends or loved ones, and then having that money converted automatically to the state's use at the end of the case was always troubling to me. Troubling for a number of reasons. First off, it's just plain black letter law, as we lawyers call it, that to say that the purpose of bail is to ensure a criminal defendant's appearance in court, period. That's it. Using this money posted with the court to ensure release seems to me to be inconsistent with the purpose of bail in the first place. Second, the worst impact of this law, obviously, is on poor people. And I gave you an extensive amount of written testimony where the practice is criticized for that very reason. I looked at a number of court decisions. The court decisions recognize, even in cases where this system of bail conversion, there are no cases in Rhode Island, by the way, but looking at court decisions in other states, even the courts that have upheld this process have said, you know, maybe the legislature ought to take a look at this because it's not the wisest thing to do. Third, this, in effect, has a chilling effect on the ability of poor people to post bail. It's something that is very clearly marked and noted on all the paperwork that must be signed when posting bail. So folks know and are informed of that fact, and the question is, and I believe, that this has a real chilling effect on the willingness of third parties to post bail. The impact on poor communities, I submit to you, is profound. I know that on the Senate side we had testimony from FANG, a community bail fund, from DARE, from the Center for Health and Justice Transformation, and all in favor of this legislation. The good news is, I think there are two pieces of good news. The first is, of all the witnesses who testified on the Senate side, and I'm going to assume it's the same case here, the only opposition that this bill received was from the judiciary. And the chair and the sponsor on the Senate side asked Mr. Boyle and I to sit down and to try to hammer out some language, and we did. Now, obviously, that's not before you, although I did provide it to you. Mr. Chairman, I hope I didn't overstep my bounds in doing that. I'm never 100% sure when I ought to do that, and I ought to refrain from doing it. But at least I can represent to you that the one opponent to this legislation, I believe, is no longer opposed because we came up with language that addressed their concerns. I'll just conclude with this. At the very core of the reforms that you folks did in 2022, reforms that you ought to be very, very proud of. I will tell you, before I finished my career as a public defender, I was privileged to work on a calendar that dealt with these cases that of individuals who owed the court money, whether it was for court costs or fees, assessments, or restitution. And I can represent to you that the change is profound. As I said, poor people are no longer required to pay court costs. And at the very core of what you did last year, I believe, was the correct recognition that it is wrong to use our criminal justice system to raise money for the state. You recognize that it was futile, counterproductive, and unfair to raise money on the backs of poor people. This legislation recognizes that this last vestige of our prior practices, bail conversion, is something that ought to be eliminated, and I would respectfully request that the committee act favorably on the sub-A that's hopefully may be before you soon. Happy to try and answer any questions you might have.
Any questions for Mike? Yes.
So good evening, Mr. Chair and members of the committee, and thank you to Representative Felix for sponsoring this bill. I wanted to speak on behalf of 6161, an act abolishing solitary confinement, reforming solitary confinement in the state. My name is Natalia Friedlander. I'm an attorney at the Rhode Island Center for Justice, and among other things, we do litigation and advocacy on behalf of incarcerated people regarding conditions of confinement at the adult correctional institutions. And through that work, I've talked with many people who have been in solitary confinement, and including 2 current clients of ours who were given disciplinary sentences of 365 days in disciplinary confinement, each for a single nonviolent offense. And what that means for them when they get 365 days is that they get at most 5 hours out of cell, 1 hour Monday through Friday, excepting weekends and holidays. They get no in-person visits, and they get a maximum of 1 10-minute phone call with family every month, greatly reduced programming, and they're basically confined in a cell with a bed and a toilet with no desk or chair, and very restricted property in their cell for 365 days. That can be extended if they keep accumulating disciplinary bookings, which other people will testify is very easy to do when you're in solitary confinement. And you'll hear more testimony about what this bill would actually do and about the impact of this practice on people. I just want to give a very brief perspective, which is that this bill actually at its core does something fairly minimal, which is to say that after 15 days in solitary confinement, which is 2 hours out of cell a day, the DOC would be required to give someone 4 hours out of cell a day. And that's the basic amount of out-of-cell time that a lot of research and science has determined is the minimum that's needed for someone to be able to function as a person. And I wanted to address kind of a larger perspective, because we have representatives from the Department of Corrections here, and expect they'll be talking about some of the things that they've been doing inside the department. And to the extent that changes are happening voluntarily, that's extremely commendable, and we certainly welcome those kinds of changes. But what I want to point out to is something even more significant than what this bill says is the fact that it exists at all, in that Rhode Island is a serious outlier compared to other states in just how little functioning of its Department of Corrections is regulated by statute. And if you look at the corrections statutes, virtually all of them give discretion to the director of the department to promulgate policies, and discretion to the director of the Department of Corrections to set aside, to regulate certain functioning of prison life. And because the Department of Corrections policies are mostly not subject to the Administrative Procedures Act, this means that the policies that govern the day-to-day life on such an intimate level of thousands of people every single year are unenforceable, and they're non-binding on the department. And what this means is that whatever the director of the Department of Corrections, whatever they decide to do with their discretion, with their policy unit, there's virtually no oversight, and there's virtually no accountability over the policies that they promulgate and the decisions that they make. And so to the extent that something might be happening, like I said, that's really wonderful, but there's no guardrails in place right now in our legislature that if another administration comes in, they could revert all the positive changes that have been happening under this current administration and institute something that's even more harsh and draconian than what we have now. We're also wanted to point out that there is, like I mentioned, we have litigation against the Department of Corrections. We're aware that to the extent that anything might happen in litigation, it's limited by the Prison Litigation Reform Act in terms of its prospective application. And so I'm here to ask you, based on the testimony that you're going to hear about the practices inside the DOC, about what this legislation actually does, that we not just rely on the goodwill of the current administration and of what's happening right now inside the DOC, and we put some kinds of guardrails in place to guarantee basic minimum out-of-cell time for people who are in the Department of Corrections. Again, this is not asking for a lot. This is asking for 15 days maximum for someone to be held with 2 hours out of cell and then 4 hours a day afterwards. That's still 20 hours a day confined in your cell. This is based, as you'll hear, on best practices and recommendations from experts. So that's it for my testimony, and thank you so much for your consideration.
Brendan? Red light's on. Is it on?
Okay, here we go. Thank you, committee members. My name is Brandon Robinson. I'm the campaign manager. I'm also formerly incarcerated. I'm someone who experienced 90 days in solitary confinement as well as 8 months in high security. What that entails is basically 23 hours a day in a cell, 1 hour out of the cell. No food after 4 o'clock, all the way into the next day, 7:30, cold air constantly blowing on you, the lights on, and you not being able to control whether you could turn it off or turn it on. So your sleep is constantly disturbed. In my time in high security, I experienced individuals who were having mental health breakdowns and hallucinating and just hearing things. At the time, I didn't understand what that was, but since then, I come to realize that it's called sensory deprivation, which is what they were experiencing. It only takes 15 days for an individual to experience sensory deprivation, where their mind starts to deteriorate. The United Nations agreed that 15 days is the maximum time an individual should be in a cell for 23 hours a day, and out of that cell 1 hour a day. What our bill is doing is trying to reform what the ACI is currently doing, because they took it upon themselves to change the rules around like 2009 and move it to 30 days in solitary confinement. And then they moved it to a year in solitary confinement. And then they moved it to indefinitely in solitary confinement. Now, when I understand that, individuals, when they do something wrong, need to be held accountable. But, and similar to when you have a pet or a child, if they do something wrong, you want to hold them accountable. But when they do something wrong, you don't torture them to hold them accountable. And that is what the ACI is doing now. They're torturing people to hold them accountable. When you have somebody in solitary confinement for years on end, to the point that they want to mutilate themselves, play in their fecal matter, or they're hearing things, and you can physically see the deterioration, there's something clearly wrong with that. And you have the power to make the changes, to change the legislation to help improve this system and these conditions. We call our bill Reform Solitary Confinement because no one is perfect, nothing is perfect. Everything can be improved, and anybody can be improved. What our bill does is allows an individual to receive, after 15 days, 4 hours out of their cell. And that does not tie the DOC's hands, as they may say. It's not saying that an individual cannot be held accountable longer than 15 days. They can still be given 30 days or 60 days for a violent infraction. But it would say that after 15 days, they would receive 20 hours in their cell and 4 hours out of their cell. And what that looks like in real time is they would receive 2 hours on the first shift, 2 hours on the second shift. That would be, that would give them the opportunity to participate in rehabilitative programming and educational programming. They can do an hour of rehabilitative programming on the first shift, an hour of educational programming on the second shift. And statistics say that an individual that participates in educational rehabilitative programming, it helps reduce the recidivism rate by 48% for each individual. And currently, if you have an individual that is in solitary confinement for 23 and 1, constantly deteriorating, and you release that individual back into our community, what do you expect that individual to do? That individual cannot maintain and build personal and professional relationships. So therefore, that individual is going to result back to what they were doing to get into that position, which is recidivate and come back to prison, which is job security for the ACI, which is what they would like to happen. But what our bill does, it just doesn't do that.
Hang on.
Yes, wait.
You just implied that the entire staff of the prison, correctional officers, the administrators, want to see people locked up so they can preserve their jobs. And I apologize for interrupting you, but I think that goes over the line. I would ask you to retract that statement. If you don't want to, that's fine, but I do not think that's true, and I think I think you're smearing them when you say something like that. I'm listening very, very closely to your testimony. I have the bill in front of me while we're doing this.
Yep.
Let's keep it civil, okay?
I'll keep it civil, and I'll apologize for that. Just so you know, I don't believe all correctional officers are bad, right? So being a correctional officer is a job. It's a 7 to 3, a 3 to 11, 11 to 7, right? Some individuals come and do their job, and some individuals bring their personal life into the job. And some people go over the board in doing their job, right? And if you look at it, if you look at the history of prison, they've worked constantly to punish people even more than what they're already being punished. They're already locked up. They're already being punished. They don't need to be punished more. And by keeping them in solitary confinement is cruel and unusual punishment, especially when you see an individual. Yes. You have a question?
He's got a question for you when you're done testifying.
Okay.
Which I'd ask you to wrap it up.
Yep,
yeah.
we'll do. Something else our bill does is it protects the vulnerable population. Individuals who are 21 and younger whose mental health hasn't fully developed. It also protects the senior citizens 60 years and older. And it also protects individuals who have mental health problems and physical disabilities. All of these individuals would not be put into solitary confinement, but would still be able to be held accountable for any infractions they may have and receive administrative confinement, which is that 20 hours in the cell, 4 hours out of their cell. And then just because of the fact that the DOC has, they're not being overseen and held accountable for their actions, we ask that an oversight committee be put in place to make sure that they're upholding the law and the rights of the individuals underneath their custody.
Jose?
So, thank you very much. I appreciate the testimony. This is a very important topic. I just wanted to ask you a couple of questions, and one of them is hard to ask, so I'm going to try to word it as carefully as possible. First question is simple. I think you said that you had served, you personally, had served 90 days in solitary confinement. Was that consecutive?
No, it was in different. It was broken up into 3 or 4 different occasions.
What was the longest period of time you served in solitary?
21 days, but high security is the equivalent of solitary confinement, so you could say 8 months, or you can break that down into what, 24 months.
So let's say 21 consecutive days in solitary confinement was the longest period of time you spent?
Yeah.
The question I want to ask you, and it's a very sensitive question to ask, and I'm almost shy to ask it, if you will, but given that you're here testifying, this is such an important topic. I've read a bunch of articles on this topic. There's a book called Solitary, written by Albert Woodfox, the person in the United States holding the record for longest amount of time in solitary, which is 40 years. What is 21 days in that environment? What can you tell us about what that experience is like?
Well, if you imagine being inside your bathroom for 21 days, stuck inside your bathroom for 21 days, right? And then you're only allowed out of your bathroom for 1 hour a day. And then on top of it, how about you add a total stranger into that bathroom with you? And then you have to share that bathroom with that total stranger. It doesn't matter if that person's sick. It doesn't matter if they have drug problems. It don't matter if they're defecating. You just have to share the same bathroom, the same cell. The toilet and the sink are connected together, and you have to do everything in that small environment the size of your common bathroom. That's what solitary confinement is like. And you can't escape it. It doesn't matter how long you yell, you cry, you scream. The door is not going to unlock for 23 hours a day. It doesn't matter how hungry you are. The only thing you have to feed yourself is water from the sink that's connected to the toilet. Sometimes the water's brown, sometimes it's not. Who knows? It's a guessing game. You got to press the button. That's solitary confinement.
I appreciate not only you coming to testify to this committee, which is an important function, but being so openly honest and vulnerable with us about what is truly a very sad part of our society. And so I appreciate the details that you're put for us and the information, and look forward to working with my committee to making progress on this issue.
And I would just like to make a correction. It's not 24 months. 8 months times 30 days would be 240 days, basically.
Yeah, thank you.
Any other questions? Okay, thank you. Is that all the experts you have? Two more? Okay, want to call them forward?
Yes. Thank you, Mr. Chairman. If Shivani Nashar and Andrew Lama can come forward, please. And then, Mike, you got a couple of more bills to testify, right?
I can sit here or I can sit there. You want me to get out? Mr. Chairman?
I think you look like the oracle of all knowledge, so why don't you stay there?
You can stick around. We'll let you hang.
My hair color, I know, it's got nothing to do with anything else.
Go ahead.
Me first? Okay. Thank you. Good evening, members of the House, and thank you to Rep. Felix for introducing this bill, and thank you all for your continued attention and energy in what's already been a very long night for all of us, I'm sure. My name is Shivani Nashar, and I am the Research Project Director at the Center for Health and Justice Transformation, and I'm here to testify in support of House Bill 6161 on behalf of my organization. Our organization was founded by Rhode Island-based physicians and researchers, and we look at the criminal justice system with a public health lens, and we seek to mitigate the health-related harms of incarceration and criminalization. While we acknowledge the challenges that you will hear of managing correctional facilities, we cannot ignore the significant detrimental health impacts of 22 to 24 hours a day of confinement. The research evidence on this topic is so compelling that more and more professional associations in the field are recommending limitations of restrictive housing, which is also termed as solitary confinement. Most notably, the National Commission on Correctional Health Care adopted the position that, quote, greater than 15 consecutive days of solitary confinement is cruel, inhumane, and degrading treatment and harmful to an individual's health, and that solitary confinement over 15 days should be eliminated as a means of punishment. The NCCHC is an independent nonprofit governed by a board of correctional health care professionals with support from every major medical association in the United States. We should absolutely bring Rhode Island in line with this reasonable guidance. While the American Correctional Association has not been forceful in its guidance, they have proposed performance-based measures for restrictive housing that include not placing anyone with what is clinically termed serious and persistent mental illness in solitary confinement for more than 30 days. Similarly, the Association of State Correctional Administrators recommends only using solitary confinement as a, quote, last resort for individuals with mental illness. Both organizations importantly stress that individuals who have spent long periods in segregation may, quote, be more likely to have mental health symptoms, to have difficulty interacting with others, or to be unprepared for life with others or in society. This begs the question, if leading prison officials admit that solitary confinement is harmful enough that people who experience it have a hard time integrating back into our general population, why is it an appropriate disciplinary tactic or prison management tool? The medical research backs up the concern about health impacts. Perhaps intuitive to many of us, prolonged isolation and solitary confinement has been linked to multiple mental health impacts, including increased anxiety, depression, paranoia, aggression, panic, hypersensitivity, insomnia, and hallucinations. People in solitary confinement also have higher rates of self-harming behavior, as well as higher rates of suicide and suicidal ideation. They also have higher rates of PTSD diagnoses. While less research has been conducted on the physical health impacts of solitary confinement, studies looking at incarcerated patients in supermax prisons, in which most residents are generally in solitary confinement conditions, have found that those patients have 31% higher hypertension rates than those in regular max security settings. Patients in supermax prisons also report skin conditions, weight fluctuations, and chronic pain related to the conditions of their confinement. A growing body of neuroscience research shows that long-term isolation likely alters the brain and could have long-term effects on cognitive functioning. Finally, those who spend time in restrictive housing have a higher post-release mortality rate, particularly from suicide, than those who do not. People who spend time in restrictive housing are in fact 24% more likely to die in their first year of release from incarceration. Longer times spent in solitary are associated with greater mortality. The vast majority of people we incarcerate here in Rhode Island will be returning to our communities. They will be our neighbors, our friends, people we work with, and people we interact with. We need to be focused on strategies that have the potential to improve people's health and behavior, rather than strategies that have been shown to make them worse. Thank you for your consideration on this important bill.
Thank you. Yes.
Hi, I'm speaking on a separate bill, so if there's no questions, I'm happy to proceed. But
Sure, go ahead. You're one of the experts that Representative Felix wanted to testify.
terrific.
So-
Thank you. Hi, everybody. Good evening. Thank you for having me. I'm speaking in favor of House Bill 6180 in favor of free communications in the state's correctional facilities. My name is Andrew Lama, and I'm a government affairs specialist at Worth Rises, a national nonprofit organization dedicated to ending the exploitation of people impacted by incarceration. We have helped jurisdictions across the country pass and implement policies that make communication free for incarcerated people and their support networks, including California, Connecticut, New York City, San Francisco, San Diego, Miami, and still others. And we are currently supporting similar campaigns in over a dozen active states and counties. With this legislation, Rhode Island has the opportunity to join these other jurisdictions on the forefront of the national movement to provide overdue relief to millions of families with incarcerated loved ones by simply making communications free. On a personal note, I began working on free communications in prisons and jails in the United States in the middle of COVID, when this was a dire, dire issue. People had no means of communication with folks on the inside, their loved ones, and I was working in the Iowa Department of Corrections, which needed a way to support free communication with their incarcerated loved ones, where I set up a free video visitation, a free video calling platform. I have submitted written testimony today, including a fact sheet and coalition letter from other organizational partners with more detail, and just want to share some highlights here. I welcome any questions after my short statement. Rhode Island families currently pay the state's prison telecom vendor, Securus, an estimated $800,000 each year to speak to their incarcerated loved ones. This money comes directly from the parents, children, spouses, siblings, grandparents, friends, and others supporting incarcerated Rhode Islanders. Families are often forced to choose between paying for basic necessities, housing, and food, and paying to hear the voices of their incarcerated loved ones. In fact, 1 in 3 families with an incarcerated loved one goes into debt trying to stay connected, and 87% of those bearing this enormous financial burden are women. The support that families provide their incarcerated loved ones can change how successful a person is both during and after their incarceration. It increases hope, reduces desperation, and encourages positive behavior, which in turn reduces violence and improves the correctional environment for incarcerated people and correctional officers alike. One study showed that verbal and physical assaults decrease by 20% when incarcerated people have regular calls, and rule violations decrease by 27% when those calls are with their children. Further, incarcerated people who maintain connection with their family, community, and support network during their incarceration have a better chance of successfully re-entering the community upon release. With their family's help, they are more likely to secure housing and employment and generally have transition support. This increased success also translates into lower recidivism and increased public safety. The Minnesota Department of Corrections study of video calls showed a decrease of more than 20% in recidivism across crimes, including violent felony offenses. Based on our work across the country, we estimate that it would cost the state as little as $175,000 to provide all of those in its custody and their families across Rhode Island with free communications. We understand the Department of Corrections has concerns about the cost of these services, but want to assuage these concerns as they draw comparisons with Connecticut, the first state to provide free communications to people in custody. First, Connecticut at the time was collecting $7 million in annual kickbacks from communication services, which dramatically increased their fiscal note. Rhode Island is not taking any commissions, which we commend the legislature for banning many years ago. Further, Connecticut's call volume did double when it passed this legislation, but that was because Connecticut's original rate at the time it went free was 32.5 cents per minute. Again, that is 10 times higher than Rhode Island's current rate, which again is at great thanks to the legislature, which many years ago passed a law requiring the DOC to more aggressively, procurement, to more aggressively negotiate these contracts. But we do not expect such significant depression of demand in Rhode Island, with rates in increase. Finally, we do expect Rhode Island to negotiate better terms with its vendor and explore some of the innovative models that are being used to further bring down its cost. We estimate that the department can make all communication free for between $175,000 and $320,000, and we urge appropriation to that extent. Finally, this is a natural moment to pass this legislation as the incumbent contract is expiring in October of this year, and this is a really perfect time to provide new guidance to procurement and the department. We urge the committee to vote yes on HB 6180. Thank you.
Any questions for the witness? Thank you. Okay. We have one witness that was out of the room. She has a couple of young children. Jessica, you going to come forward? It's a LEOBOR witness, the last one. Jessica, you can testify. Go ahead.
Thank you. I'm here because I am here to oppose Bill 5561. And I am saying this as a formerly incarcerated person. My daughter, who is here with me, 17 years old, watched pretty much me getting arrested for a lot of her younger life. She was afraid of the police. Every time she's seen them, she would cry. So at some point, I had to start taking accountability and realizing that those negative experiences for her were because of me, not because of the police, but because of everything that I was doing, the situations that I put her in. Now, she's in the Explorers program and inspiring to be a cop. And I think because of her experiences in watching her mom be arrested more than once, she will have the most amount of empathy and be able to do her job successfully. So being involved in her program, and I'm sorry, this is a little emotional for me because I'm not used to putting my entire business out here, but I felt like it was important for her that I did this. Being able to work with the police, I'd have to say, is a flex for me, knowing where I came from. Getting to know their job, to realizing that you cannot just go from a domestic violence situation that involved children being hurt and then go to a traffic stop and snap out of that mindset. They're humans too. They're already having a problem now getting good cops, keeping good cops. Vilifying them is not going to help. They need more support. They need to be in the communities. Children need to see them out in the communities, not just when it's a negative interaction. And I feel like all we've been doing is tying their hands and not allowing them to do that. And that's not going to be, good for them. I mean, we have state police that keep our governor safe. We need the police to keep our children safe. We need police in the schools to keep our kids safe. And we're not going to have these officers anymore if we take away a protection that they have. And it is fair. I've seen the process. I know the process. I actually went on our ride-alongs and asked a bunch of questions about the process, about their job, about how they feel about wearing body cams. They have no problems with it. They want the accountability. They don't want to sit here and be vilified for any cops that are doing the bad things that make them look bad. They don't want that. They want good officers, and they're not going to get them if they don't feel supported. And I want to make sure that my daughter is supported. And this is how I'm doing it. Thank you for listening.
Thank you very much. I'm sure that sometime between your daughter seeing you get arrested and today, you did a lot of good too. So thanks for coming forward. All right, we've got 4 more bills to put in play. Julie, you want to put your bill in play now? Yeah, I'm just going to put the rest of the bills. Then I'm going to call people up. They could testify on any bill they want.
So I'm putting bill number 6139 in play right now. It's the Second Look Sentencing Act. The act would establish the Second Look Act and would permit incarcerated individuals to petition the sentencing court to consider a motion to reduce the sentence after the defendant has served at least 10 years of the sentence. I want to direct your attention. I know you probably all read the written testimony, but in mid-February, the Providence Journal ran a story about Judge Procaccini and a case that was in front of him. Judge Procaccini asked the Rhode Island General Assembly to empower judges to take a second look at cases for young offenders serving long sentences. I have testimony from Galil Oliveira, whose case was also mentioned in the article, and I will be reading his testimony as well. But it seems right now that society is rediscovering the value of rehabilitation, especially as it relates to young people. Many states are enacting this very legislation, which is supported by the National Association of Criminal Defense Lawyers. The Model Penal Code and American Bar Association both recommend mechanisms to re-examine cases. The Rhode Island Association of Criminal Defense Attorneys embraced Judge Procaccini's call for more judicial latitude. The Rhode Island Council of Churches supports this bill, and we also have a letter from the former chair of the Rhode Island Parole Board, an 11-year member who is in support of this bill. The judiciary is crying out for discretion to address lengthy sentences after true rehabilitation has been achieved. Rhode Island needs to embrace the rehabilitative ideal. Our state has grown far too punitive over the years with our young offenders. There is a ton of written testimony online that was submitted and articles supporting this very topic. I hope you at least take a look at it. There's really a lot of support for this type of change, and as far as I know, there has been no opposition to this bill. We need to give the judges the leeway they're asking for. Let me be clear. This is by no means a get-out-of-jail-free card. This is not what this is about. This is about giving leeway to judges when they need it. A person has to be truly rehabilitated. So I'd like to just read Galil's story to you because I think it's very powerful. Hello, everyone. I would like to thank the Judiciary Committee for hearing this bill and allowing me to give testimony today. My name is Galil Oliveira, and I'm currently serving a life plus 40 years sentence at the Adult Correctional Institution. I want to start by saying that I'm sorry for the things that I did when I was younger, and I know that I can never take back what I did and the pain that I've caused. I could only demonstrate and do the work that was needed to be done to change and better myself as a human being, spending the rest of my life living the right way and doing the work that's needed to achieve that. That is how I spend my time in prison. I came into prison at the age of 23. I will be 51 years old in less than 2 weeks. So I've spent more than 27 years inside. You may or may not know about an article that was written in the Providence Journal about me and also about Judge Daniel Procaccini, who asked the Rhode Island legislature to pass a Second Look Sentencing Act bill. He did so in response to him having to deny the post-conviction application that I filed in front of him. Being in front of Judge Procaccini, knowing that I've given my life to change, to helping others and doing the long, hard work, and that what it takes to become truly rehabilitated, and then find out he believes in my rehabilitation, but he couldn't give me the relief that I was asking for because he doesn't have the discretion to do so. It was a traumatic experience to find out that the judge, the decision maker, couldn't legally make the decision that he wanted to make. The judges that are respected, trusted, and entrusted to make the big decisions and give people X amount of years should also be trusted to have the discretion to take some time away if the person has served a substantial amount of time, met all the requirements, and more so are truly rehabilitated. I know that some of you may be a bit skeptical about this bill because you worry that many people may get released because of it, but I don't believe that this is the case at all. Like I said earlier, judges are respected, trusted, and very smart, so they will be extremely critical and cautious about who they would even entertain to give a second look to. So the few people that may get the second look, that are the ones that need it, and only the ones that truly deserve it. So I ask all of you to please pass this bill and be confident knowing that the judges, the ones that you have entrusted to do the right decisions, will handle this responsibly and will only choose the ones that truly deserve a second look. I think it's very compelling that Judge Procaccini is asking us to give him this leeway, and I think that we really should take a really good look at this bill. Like I said, I don't believe there's any opposition to the bill. I could be wrong, but I don't believe there's any opposition to the bill. So thank you.
Thank you very much, and there might not be any more testimony to that. Let me just check and make sure.
Yeah, there is.
Oh, there is? Okay, all
There
right.
he sits right in front of you. Mike DeLauro.
Oh, I know, but he said in your bill, he's not speaking. No, that's what he said.
Doc has a question.
Okay, Doc.
Very quickly.
No, that's 5149.
Oh, okay.
3988.
All right.
I'm sorry, Mr.
Representative Casimiro, would this pertain to only certain crimes?
It would be at the judge's discretion. So it won't be, right now, the way it's written, I don't believe it'll affect life without parole.
I'm sorry.
I don't believe it'll affect life without parole.
Okay.
But it would include all categories of crimes
It would include murder,
and other?
Mhm.
Okay.
but
Thank-
it would be someone who was truly rehabilitated and someone who was sentenced as a minor who committed that crime as a minor.
I think the bill has potential. Probably needs to be a little tweaked here and there.
If you remember 2 years ago when we passed Mario's law, we had a ton of witnesses that came forward and talked about the brain science behind young offenders. And this is just in step with Mario's law. And Mario's law ended up getting, I think, 4 juvenile offenders out of jail or out of prison already. This one, again, is people who are committing crimes when their brains are not fully developed and not really responsible for what they're doing. I don't mean to say responsible, but it's going after the young offenders.
All right, we've got a bill by Representative Jello. Would you like to put that in play, Edie?
Yes, I would.
Okay.
Chairman Craven. 5889 is a legislation that I've introduced at the request of the Human Rights Commission, the ACLU, and the Coalition for Community and Justice. This legislation would restart the collection of police traffic stop information, so it would restart the collection of when someone is stopped, what their race or ethnicity is, whether the car is searched, whether it's a voluntary search or not, whether anything was found, and whether an arrest was taken. Rhode Island did these traffic stops with money from the federal government through Department of Transportation. That collection of information ended in 2018 or 2019, and we think that it is time to start collecting that data again. Some communities, the police were found to be disproportionately stopping people of color and certain ethnic groups. Really, that needs to be looked at. And one of the most, I think, should be startling to everybody, but also a lesson learned. What they found in comparing the records of automobiles searched after the stop was that they found disproportionately found contraband in cars driven by Caucasian people, white people, as opposed to cars driven by people of color. People of color were stopped, however, much more often, proportionally. We think it's time to start this study again, as I said, and very interestingly, we learned through Brian Emerald of the Boston Globe's research a month or two ago that the Department of Transportation, Rhode Island Department of Transportation, has applied over the last couple of years since the study stopped for new money from the federal government to do the study again, but we're not doing it. So the money is there to pay for the study. We should start doing it again. This legislation is actually now the result of compromise talks between the three groups that I mentioned and police representatives and the Department of Transportation, I believe. So it's compromise already, and I think ready to go, and I urge passage. Thank you, Mr. Chairman.
Thank you, Edie. Yes, Jose.
I just want to make a comment on this bill and thank Representative Agello for submitting it. In 2019, when I was the executive director of the Para Board in Providence doing police oversight, we relied heavily on this research, and it gave us a strong, independent, academically rooted angle by which to study something that we largely know. And I can't speak to how valuable this information was and how unfortunate it was that the study stopped. And so I thank you for this. This was very important. Obviously, a lot of the things that we talk about in this committee are very heavy and very difficult, racism and discrimination, but the reality is that even outside of people who have bad intent, malicious intent, bias is real. We're all human beings, we all make mistakes, and this research, we were able to deduce important findings from this research. And so I look forward to supporting this. I hope the state implements it again. We have a lot to learn, and we can't fix a problem unless we acknowledge there is a problem, and this bill helps make that case. So thank you very much for your leadership.
Thank you. All right, the next bill we have is sponsored by Representative Cruz. Would you like to put it in play? It's House
Yes,
Bill 5686.
Yes, thank you, Chairman. This legislation would require the consideration of the status of a defendant, either as a parent or a primary caregiver for an elderly, terminally ill, or disabled family member at their sentencing, and allow the presentation of a family impact statement as a component of the sentencing process, and consideration of community-based alternatives. It's well-known parent-child separation as a result of the criminal legal system involvement is a traumatic experience for both parents and children alike. Parental incarceration is considered one of the 10 adverse childhood experiences. And parental incarceration is a significant turning point in a child's life that produces long-term negative effects long after childhood. Currently, the incarcerated population in Rhode Island has an average of 2 children per commitment as of fiscal year 2022, with Black, Hispanic, and Native American populations disproportionately incarcerated. As a result, racial and ethnic minority families are disproportionately torn apart. And in recent years, the percentage of children entering foster care due to parental incarceration has increased. This bill can serve to mitigate racial disparities in the criminal legal and child welfare systems. This bill is deeply rooted in the well-being of the family, of the whole family, one that is not an afterthought, but is intentional in the judicial process and focuses on reducing trauma unnecessarily through incarceration for the family and keeping families together.
Thank you. Now we have 3 bills. There's no questions of the sponsor? Okay. We have 3 bills by Representative Place. Do you want to put them in play, Dave?
Thank you, Mr. Chairman. We'll start off, what is it, 5296? 5290, well, all 3 bills really is just an attempt to bring our laws in line with technological advancements. This first one deals with the data transfer, where the stuff we take on our phones, where it gets stored, and asks that the law enforcement actually have to get a search warrant to access the data that we send up, whether it's the cloud or wherever it winds up being stored. Not only the data, but our location. And I just think it goes a long way to just bringing our technology in line with the intent of our founders in the Constitution, with our protection against search and seizure. Let's see. 5211 comes out of some research I did. I just think that at one point in time, the Supreme Court erred in what's called the open fields doctrine, which they stated that if a person is not free from surveillance on their property, if the surveillance is set up too far away from their actual house or their chattel. And I just think Rhode Island should recognize that a person's property is their property, and in order to put any kind of device on there to record them or other people, that they need to get a search warrant in order to do that as well. And finally, 5566 prohibits the use of Stingray cell site simulator devices by law enforcement agencies except upon application for its use and the granting of an order by the presiding judge of the Superior Court. Again, just bringing our laws up to date with the technological advancements. If you want to do a trap and trace, you need a warrant. you should need a warrant in order to collect individuals' data. You can't throw up a fake cell site and force people to connect it and collect their data without a warrant. In my mind, that's a search and that's a seizure. And our laws should reflect that. So, Chairman, those are the three bills, and thank you for the consideration.
Thank you very much. So the next two bills I'll put in play myself, and then we'll be done. It's two bills sponsored by Chairman Solomon. The first is 6163. It's a resolution creating a special legislative task force to improve the long-term outcomes and reduce recidivism of females within the criminal justice population. And the last one for tonight to be put in play is also sponsored by Chairman Solomon, and it's a House resolution respectfully requesting information and guidance from the Rhode Island Department of Human Services, DHS, in conjunction with the Rhode Island Department of Corrections, DOC, for transitioning females in the criminal justice system through pre- and post-release. So they're all in play. Now we're going to go back to finish, hopefully, all the rest of the bills. And what I'm going to propose, because we have several people here that have been waiting a while and they have jobs that I think they have to show up first thing in the morning for. Mike, would you step back for a minute? And I'm going to put all your bills through at the same time, okay? I'm going to have you testify on all of your bills at the same time. These three individuals here are only going to be testifying on the Solitary Confinement Reform Act, which they're all going to be put in play. They're all in play now, and then I'm just going to simply call people forward, name you, and I'm going to say testify on all the bills that you wish to testify on. That way it actually speeds things up. Okay? So would you step back just for a minute so I can get these three people up here? Thank you. Wayne Salisbury, Joshua McComber, and Caitlin Bouchard. Director?
Thank you, Chairman Craven. I know you spoke, we're just going to speak to 6161. I just wanted to comment briefly on 5562. I did have a prepared statement, but just that was involving correctional industries in good time, where we had Representative Diaz's bill we submitted a letter in support of, and it just increases the good time amount from 2 to 5 days. Just want you to know that the department is in support of that. With that being said, I will try to be as brief in my comments as possible.
I would appreciate that. Thanks.
Yes, sir. Again, good evening, Chairman Craven and members of the committee. I appreciate the opportunity to sit before you this evening to speak on this legislation. For those of you I have not had the opportunity to meet, my name is Wayne Salisbury. I'm the Acting Director of the Department of Corrections. I am humbled and honored to serve in this role and understand the enormous responsibility I have to the offenders entrusted to the department's care, the staff, its vendors, community partners, and to the families, friends, and constituents of our great state. Before I speak to the legislation, I believe it's important to know my background. I sit before you this evening with 36 years of law enforcement and corrections experience. I served 6 years on active duty in the United States Air Force as a law enforcement specialist and trainer performing police and corrections duties in the United States and overseas. Following active duty, I began my career as a correctional officer and promoted through the ranks of sergeant, lieutenant, captain, chief of security, associate warden, and eventually warden. During those years, I was instructor certified in various use of force modalities such as firearms, defensive tactics, chemical agents, and baton, to name a few. But more importantly, I was a trained crisis negotiator, a skill most utilized and necessary in dealing with offenders. Lastly, I was a certified auditor for the American Correctional Association for over 13 years, having the ability to travel around the country and observe and evaluate other correctional agencies and systems. In March of 2016, I joined the Rhode Island Department of Corrections as a deputy warden and was assigned to the Intake Service Center, and within a year assumed the role of acting warden. In October of 2020, I was promoted to the role of Assistant Director of Administration and to my current role in January of this year. Shortly after joining the department in 2016, I joined the National Institute of Corrections training staff as an instructor in managing restrictive housing populations
becoming the lead facilitator in 2020. I have facilitated restrictive housing training for nearly 80 agencies around the country and have consulted and assisted many agencies on this very subject, most recently assessing the Pontiac Correctional Facility in Illinois in October of 2022. This evening, you will certainly hear testimony contrary to what myself and my staff will say, most of which may have occurred years ago. The emotions associated with this topic will make it difficult to ascertain what is true and what is false. Sadly, some of it is true. What I can tell you unequivocally is that the stories you will hear tonight do not represent current practices at the Rhode Island Department of Corrections. I will say that if that's their perception, then it's their reality. I respect their reality and will use their reality in our reformatory efforts. Restrictive housing has long been a feature of Americans' jails and prisons. The justifications for its use have varied over time, as we've heard this evening, and so has the acceptance of its practice. Solitary confinement is complete sensory isolation and total social isolation. Complete sensory isolation, coupled with total social isolation, can destroy the personality and constitutes a form of inhumane treatment, which cannot be justified by the requirements of security or for any other reason. Solitary confinement has been widely abused across the globe over the years out of fear of who we were dealing with or being mad at the offender. Why is this important to the members of this committee? It's important to understand where we came from, where we are, and where we're going, to include some lessons along the way. That is not who the Rhode Island Department of Corrections is, nor will it be. The department is committed to being transparent, and in doing so has invited countless members of the legislature to tour our facilities. Our restrictive housing population is about 5% of our total population, which is less than where we were just 3 years ago. As you are aware, the department is currently in federal litigation and mediation regarding restrictive housing, and have 2 neutral court-appointed monitors that have worked with all the involved parties for nearly a year. We have made significant progress in our mediation process, and I firmly believe that if we're able to continue on this path, this legislative body and our reform advocates will be pleased with the outcome. It is important to keep in mind that this is a critical part of our mission to contribute to public safety by maintaining a balanced correctional system of institutional and community programs. We do not have solitary confinement. More than just a change in terminology, our restrictive housing practices are well-crafted step-down programs that seek compliance through the use of privileges rather than retaliatory methodology. In other words, the more the offenders comply with the rules, the more privileges they are awarded. We are providing a range of custodial options, supervision, and rehabilitative services to facilitate successful offender reentry into general population and to the community upon release. We have increased out-of-cell time and allowing the use of TVs, radios, tablets, and MP3 players to folks that are in restrictive housing. To that end, we have implemented a series of step-down programs to manage offender behavior and to ensure safety inside our secure facilities. Captain Joshua Maycomber, to my left, will speak more specifically to these changes in his testimony. We have established a residential treatment unit for qualified SPMI, as you've heard, severely, persistently mentally ill folks, along with a behavior modification unit. Acting Clinical Services Director Caitlin Bouchard, to my right, will speak directly to these matters in the clinical treatment of those in our care in her testimony. Although there is a national trend to impose legislation on restrictive housing, it can lead to disastrous results. The Department of Justice published its guiding principles concerning the use of restrictive housing in January of 2016. And nowhere within those principles does it call for the elimination of restrictive housing, limitation of disciplinary confinement to 15 days, restrictions on age of anyone under the age of 22, or someone over a certain age, as outlined in this legislation. Much legislation has been modeled after Rikers Island and New York State around the country. Members of this committee, as many jurisdictions are seeing around the country, one size does not fit all, as each correctional system is different in so many ways. Within New York State, according to reports from September 22, since the implementation of the HALT Act in April of 22, there were over 1,000 assault incidents, with the overall prison violence going up 27%, of which 88% of the assault incidents resulted in staff injury. I say this not to deter us from reform, but to caution us to the pitfalls. We deal with real people, with real issues, and people that have proven to be violent, assaultive, and a threat to the safety of others within our correctional systems at times. The staff within the department are dedicated to providing safe, secure, and humane facilities throughout our complex and do a tremendous job with the resources and space that we have. We are not perfect, nor do we claim to be, as we are all human just like those we manage. We strive each day to make today better than yesterday for our offenders and staff alike. We are a work in progress and we are constantly evolving, just like the history of restrictive housing, just at a faster pace. I began my testimony this evening speaking of the incredible responsibility I have to ensure the safety of all entrusted to the department's care, to include its offenders, staff, vendors, visitors, and all that pass through the walls of our facilities. With that comes great authority. I ask this body not to jeopardize the safety of our facilities by imposing such broad legislation that imposes upon the director's authority while still making them the responsible party. We did hear testimony tonight about watching HBO in solitary confinement. I implore you not to do that. I implore you to come visit the ACI and visit the areas that are referred to by our friends here as solitary confinement for yourself. Anytime, any day, unannounced. You're more than welcome. I'll be pleased to answer any questions you may have.
Thank you. Any questions? Representative Knight.
Thank you, Director, and welcome. You indicated in your testimony that about 5% of the population is in restrictive housing right now. What does that translate to in terms of numbers?
So anywhere from 100 to 125 reps.
Like right now?
Right now.
Okay. Do you know what the average stay is for those 100 to 125?
16 to 17 days in restrictive housing.
Okay. Is that average stay, how long has that been the average? Is that that's the average today?
It's been pretty consistent for the data I have over the last 3 years.
Over the last 3 years?
Yes, sir.
So you're saying, so the bill calls for a maximum of disciplinary confinement for 15 days. And if I'm hearing you right, you're saying generally speaking, your average stay is 16 to 17 right now.
Average length of stay in disciplinary confinement is 16, 17 days.
Who has been locked up the longest in restrictive housing? What's the longest stay you have right now of those 100 to 125?
I'll defer to Captain Maycomer, and he'll have a better idea.
Okay. When somebody is in restrictive housing right now, what's their out-of-cell time like?
So we have two versions of restrictive housing right now. And again, we are working with our court-appointed monitors and our litigation and mediation, so I just want to be very careful and not being coy with the committee by any means.
Right.
We have two areas of restrictive housing that we'll refer to. One is our disciplinary confinement unit, and then we've heard testimony tonight about high security, where we have our, we've renamed it to restorative housing over in that area. And Captain Maycomer can speak to that, but those folks over there are out 4 hours a day. And there is a lot of programming that goes on in that particular area.
Is that for the persistently mentally ill folks?
So
or is that a different program?
Yeah, they're over there, but it's a different group, which Caitlin can speak to as well.
That's a whole thing. It just happens to be at high security because that's where the space was, right?
Correct.
Okay. So that's disciplinary, or excuse me, high security, you get out of cell time around 4 hours a day?
Correct.
What's the other kind of restrictive housing?
So disciplinary confinement unit right now is about 2 hours a day.
Okay. Thank you. Thank you.
Anybody else going to testify?
Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to return to testify here this evening. My name is Caitlin Bouchard, and I'm the Acting Clinical Director for the Rhode Island Department of Corrections. I have spent more than 15 years in correctional mental health care, serving as a clinical programming services provider, a clinical social worker. I entered a supervisory role in 2014, and then I moved into my current role in April of 2019. I currently oversee our behavioral health unit, which consists of 13 qualified mental health professionals, including master's levels clinicians, licensed independent clinical social workers, licensed mental health counselors. And we also have contracted psychiatric services with Rhode Island Hospital, Lifespan, and also a forensic psychiatry fellowship program with Eleanor Slater Hospital, with psychiatric services provided to the correctional population by forensic psychiatry fellows as a part of that program. Our mental health professionals provide services 7 days a week for first and second shift hours, and we also have on-call services 24/7 by both psychiatry as well as the mental health clinicians. Psychiatric clinics are held 6 days per week, again with 24/7 psychiatric on-call coverage for emergencies, which unfortunately are not that uncommon in corrections. The Department of Corrections has taken a proactive approach to addressing the needs of the severely and persistently mentally ill, or I'll refer to for time as SPMI patients. In February 2018, we opened our residential treatment unit, which is a treatment-intensive programming unit that houses the SPMI population or patients who are identified as requiring a higher need of care as a result of functional impairment that may affect their ability to thrive in general population. This unit focuses on moving these SPMI patients out of restrictive housing and into a therapeutic treatment setting. Each patient has an individualized treatment plan that includes psychotherapy, evidence-based programming, psychiatric occupational therapy, medication management, and their progress is reviewed monthly in a multidisciplinary team committee. A second specialized treatment unit is currently in the final steps of development that would provide a long-term housing placement for SPMI patients who present with more complex clinical needs, including those with personality disorders, impulse control issues, and those that, again, have difficulty functioning in general population. This unit will divert these SPMI patients from restrictive housing and provide them with enhanced clinical programming and additional supports, and we anticipate this unit to be operational by fall 2023. The clinical treatment team reviews all disciplinary infractions daily. The electronic medical record of any patient with an infraction is fully reviewed to determine if there are any active symptoms or functional impairment that could have played a role in the infraction. Any SPMI patient who receives a disciplinary infraction is assessed within 24 hours by a qualified mental health professional in a confidential out-of-cell session. For patients not designated SPMI, if mental status is suspected by one of the qualified mental health professionals to have played a role in the behavior involved in the infraction, then they would, of course, also be assessed in an out-of-cell confidential evaluation. If mental status is found to be a factor, this is reported by policy to shift command and is a key factor in the disciplinary hearing process. All individuals placed in restrictive housing are consistently evaluated by the clinical treatment team to assess their mental status and to provide them with clinically appropriate mental health and psychiatric treatment for the entirety of their placement. If a patient is receiving active clinical treatment services, that treatment plan does not alter or change when they get placed into restrictive housing. Their treatment plan would continue when they get placed into restrictive housing. Some of the examples of the clinical treatment plans we have for individuals in restrictive housing include identifying underlying causes of the behavior that led to the infraction, development of adaptive coping skills, increasing frustration tolerance, and employing cognitive behavioral therapy, dialectical behavioral therapy, and trauma-informed care, with a focus on preparing the patient for returning to general population and eventually, of course, reentry into the community. All individuals in restrictive housing have access to confidential out-of-cell sessions with a qualified mental health professional. These professionals are also present in the restrictive housing units for weekly rounds and often a daily presence depending on the facility, consistently assessing the patients in the units for emergence of any clinically significant symptoms or functional impairment. Additionally, they check medication compliance and ensure that the patient is adhering to their activities of daily living without any impairment. Mental health professionals consult daily with correctional and medical staff regarding their observations of the individuals in restrictive housing as it relates to changes in their behavior, presentation, sleeping, eating patterns. Our medical professional staff are in the units every day, every shift. This collateral information combined with the ongoing assessments ensures that all those patients or individuals that are housed in restrictive housing are continuously assessed for any signs of psychological distress. Individuals in restrictive housing can also request to meet with a mental health professional or member of psychiatry at any point in their stay, and the department prioritizes the accommodation of these requests. I am proud to be part of the department's continued organic evolution and how those in our custody receive care, and as we continue through our ongoing mediation and litigation, I am confident further progress can be achieved to the benefit of our patients and the department as a whole. Thank you.
Thank you. Lieutenant, are you going to testify, or is it Captain?
Captain.
Am I It looks like lieutenant.
Yeah, I have captain's bars. I'm still awaiting a new name tag. Supply chain issues.
Recently promoted, Mr.
Director,
Chairman.
will you buy the guy a new name tag?
I'm trying, sir.
Crying out loud.
I'm actually, I'm
pitch
at Senate
in here.
Finance on Thursday. I want to get some chairs for this room first.
Yeah, these are chairs designed to hurt the rear end, that's for sure. Captain.
Thank you, Mr. Chairman and members of this committee. My name is Joshua Maycumber. I have served the state at the Department of Corrections for 24 years, with the last 14 years in a supervisory role as lieutenant. This year, I had the honor of being promoted to captain in February. I've spent most of my career at high security and maximum security, two of our most challenging facilities to manage. As the legislatures who have toured high security have seen, our officers and supervisors strive to provide the safest and most secure environment possible. This requires awareness and sound judgment during each minute of each shift. The individuals my team and I look after and care for present a variety of complex challenges and needs. A phrase we use often in corrections is care, custody, and control. It is these considerations that allow for opportunities for rehabilitation or to dictate how an individual must otherwise be managed. It is our role to foster and help maintain a clean, safe, and healthy environment that lends itself to these goals and priorities. Officers spend more time with the incarcerated population than anyone else, to include their own family members at times. As sworn peace officers, we have a duty to protect them from one another and, unfortunately, many times from themselves. As important as it is to end an incident that is occurring in real time, it is equally important for us to prevent incidents before they happen. Officers are usually the first to detect an issue or red flags with someone. We notice if they miss a meal, miss a visit, or refuse recreation. We sense if they are depressed, upset, or scared. We observe their interactions with their peers. All of this done by proactively engaging with the population and treating them with respect and as people. Ultimately, they depend on us to ensure their safety. Our policies and procedures today, including restrictive housing, are not capricious and arbitrary. There is a logical reason for each policy and procedure we follow. If an individual in our custody is not permitted to have a particular item in their cell, it is based upon a previous event or circumstance which created a risk or danger to that individual and those around him. I could provide countless examples of real-life incidents that resulted in changes to policy or procedure designed to enhance the safety of individuals. I am proud of the work I have done over the course of my career, particularly the contributions I have been able to make as RIDOC works to continuously evolve its operations in a manner that is consistent with best correctional practices. A sad reality is that many of our facilities do not lend themselves to best correctional practices, as they were built at a time when program and rehabilitation were not prioritized as they are today. In my opinion, as a correctional professional, a reduction of sanctions as proposed in this legislation makes an already challenging and difficult job of keeping those who depend on us to keep them safe even more challenging, if not impossible. I'd like to thank you for the opportunity to speak on this very important issue. If you have any questions, I'll do my best to answer them.
Thanks.
I'm just going to ask you that question I asked the director, and he referred over to you. What's currently, of the 100 to 125 people in restrictive housing, who has been in the longest?
I can only speak to high security and maximum security. I believe the person is at high security. I don't have their exact number off the top of my head. I would say it's close to 260 to 300 days.
Right now?
Yeah.
Okay.
We've tried to repeatedly to reintroduce him to the population, and he continues to assault staff.
Right.
Approximately 2 weeks ago, we broke an officer's eye socket. 3 months ago, he bit me and spit in my face, as well as attacked a social worker.
Okay. And I'm not going to ask any questions about the persons because I don't want to talk about any one person, but but that's the number I wanted to get, because I'm just trying to get a sense of where you guys are now
Yeah,
in
that
terms of,
that
because like
individual
20
is-
years ago was a different story,
Yeah.
right?
That individual is an outlier for us.
Okay. Do you know what the next highest is? And if you don't, you don't.
I could, a rough estimate, would I'd say maybe 45 days.
Okay, thank you.
Okay, Representative Felix.
Thank you, Mr. Chairman, and thank you all for coming by and testifying on this legislation. I just have one question. So we heard about different practices and the things that you guys are all doing. Protecting individually identifiable data from the individuals that are currently in there, are you able to provide the committee access to disciplinary records and classification records necessary to evaluate the conditions and protocols that you guys currently have in place?
So I would have to check with our legal department to see if that is public information, Rep.
Okay.
That'd be a concern
Yeah,
that I would
'cause-
have. I think we had an incident in Senate Judiciary where somebody was releasing some information, and obviously that poses an issue. So I would have to follow up and get back to you on that.
Thank you. I would ask that it be compliant, obviously, with the APRA, make sure that no personal identifiable information is there. It's just in terms of at least learning a little bit of what has been done. So, for example, it's been testified regarding inmates being consistently evaluated. What is consistently, and how is that defined? In terms of, in particular, what is the average of that consistently when folks are asking for an evaluation to see a mental health professional? So things to that regard that will help the committee make these determinations and kind of see where you guys are at to better help explain your day-to-day conditions.
Okay, and I think in your request, Rep. Felix, you talk about two different things. When you talk about disciplinary records, and then we're talking about medical information, which is obviously HIPAA protected in the EMR, so that would be difficult to provide that. I don't know how we could do that one. That would be a little tricky, but again, I could check on that for legal with you. Okay.
One quick one.
Yes.
It's an unanswerable question. I'm going to ask you because I'm curious. You said you had some mediation going, and I think that's a result of some federal litigation around this very issue. I'm sure you can't answer this. Any idea when that's going to wrap up?
Actually, we're very close. I would say by the end of the summer, I think we'll be in a very good place.
And you anticipate that will come up with conclusions in order to resolve a case in controversy, meaning some compromises will be made and some new policies will most likely become of that?
Yes.
All right.
No, it's two cases. There's two. It was two. Okay, thanks. Any other questions? Thank you, guys.
Thank you.
Ma'am? Okay, we've got 7 witnesses we've got to deal with fairly quickly. They got to get back, but Richard Ferruccio and Joe Almeida are going to come forward first. And then one of those witnesses is Keith Nunes. Is he available? Richard, make sure everybody's got their red light on. And Keith, you're going to testify on the Edwards bill, the Life Without Parole bill?
Yes, sir.
Okay. These guys are going to talk about solitary confinement, I guess.
Oh, yeah.
Yeah.
Who's first?
Well, you are.
Well, then, all right, thank you. Well, good evening, Mr. Chairman, members of the committee. My name is Richard Ferruccio. I'm the president of the Rhode Island Brotherhood of Correctional Officers. I'm honored to be able to speak with you about this very important piece of legislation. I'm also a correctional officer with almost 39 years of experience at the Rhode Island Department of Corrections. My testimony today will be based on my year's experience as a corrections officer. This legislation before you, we believe is extremely dangerous and will jeopardize the safety and security of the inmates that are held at the Department of Corrections and the correctional line staff, most of whom I represent. Of the thousands of bills that are in front of this General Assembly, this session, I believe, in my opinion, this is one of the most dangerous. This legislation would significantly alter the discipline process at the Rhode Island Department of Corrections. And so everybody understands the discipline process is very similar to the criminal laws of the state of Rhode Island. The disciplinary confinement units are like the prisons within a prison, just so you can understand what we're talking about. As I stated, this legislation would really reduce the penalties for violations at the Department of Corrections of the discipline process. Ironically, if these changes are ever enacted, we would look for other tools to basically manage our population. We have looked at criminally charging inmates for every violation of the department policy, because every violation of the department's policy can be matched to a violation of Rhode Island general laws. For example, threatening, possession of illegal drugs, assault. We could potentially criminally charge people with those. Or another alternative that I've looked at would be to use the Superior Court 32F probation violation for serious infractions of not complying with keeping the peace and good behavior while in custody at the Rhode Island Department of Corrections. I believe case law more than supports that use. So instead of time in a disciplinary confinement unit, an inmate may have to serve additional time in prison. It's just tools that we're looking for. We want to manage the facilities. The Department of Corrections, while not perfect, is one of, if not, I think, the best-run Department of Corrections in the country, and our safety record more than supports that statement. We have an incredible group of men and women who put their lives on the line every day in the name of public safety at the Rhode Island Department of Corrections. You may have all seen our tagline representing those who work the toughest beat in the state. Well, I can tell you the Rhode Island correctional officers earned that, because in the 70s and the 80s, when I started, the ACI was a very dangerous place. Not because we didn't have a good group of correctional officers. We had an incredible group of correctional officers, but because there wasn't really no discipline. There was no control at the ACI. The staff didn't have the tools to effectively manage the facilities. The Rhode Island DOC discipline process is one of those most important tools that we have to manage our department. And today, the ACI is a very different place as a result. As I stated, we currently operate one of the safest prisons in the systems in the country. And this legislation would undo that hard work and sacrifice to get where we are today. On April 1st of 2022, the state of New York enacted this similar legislation, I think with horrific results. The New York Correctional Officers Union press release is included in the package that I put out. What they basically said is that in their data supports that 2022 was the most violent year in New York State history. So I ask you to take a look at it. That's my counterparts in New York that put that out. That's on their website. That's where I got it. The president of New York was willing to come down and testify if it was necessary. What I will tell you is that this legislation will also invalidate the tremendous work that the 2016 Commission to study the use of solitary confinement was held here in this very room. Many long nights. That commission spent an extraordinary amount of time to develop the discipline process that we're using today, and this would be eliminated if this legislation became law. Many of the inmates who are going to testify here today, they testified in the Senate. What I will tell you is their time predates the 2016 changes that we enacted. Back in 2016, we had similar hearings to what's going on here today. What I will tell you, the commission then had to deal with a number of problems where witnesses, ex-inmates, were testifying to mislead this committee with some inaccurate information. And I guess that's some of the things that I've been accused of frustrating some people about.
Mr. Ferruccio?
Yes, sir.
I would ask, in the spirit of fairness, if we could just confine our testimony to what you know and not talk about the motives or intents of other witnesses.
Sure.
This is a very, very difficult topic, and
I understand.
just trying to get to the truth of the matter.
What I'm going to tell you, that what happened was in the Senate, the same bill was heard in the Senate. In 2016, the reason I say the commission had to deal with it is in 2016, we had a number of witnesses that came in and said things. They were never even incarcerated at the ACI. Last week, we had a former inmate that came in and testified. I don't know if he signed up to testify tonight. His name's Brandon Dawkins. He came in last week and testified, and he gave some really powerful testimony that he was at the high security center and he was in a cell next door to an inmate that the correctional officers killed. And I say that with some frustration, because it was the furthest thing from the truth. Ironically, that inmate, and I included it, when the inmate that he said that alleged that the correctional officers had killed, which was a huge false testimony, and he got a standing ovation for his testimony. On 1/6/2011, the inmate he mentioned was Denard Walker. Inmate died early in the morning on 1/6/2011, and the inmate that Brandon Dawkins that said he was in the cell next door was bailed on 1/6/2011 from the Intake Service Center. I say that because it's frustrating, because when we have a group of people that are going to come up here and misspeak, maybe that's the nicest way to put it, I just ask that they, you know what, when they come up here and they testify and they say, I did 2 years in solitary, 2 years in discipline, I got taken into solitary for stealing an apple or taking food out. I expect it to be the truth. And what happens when I look at their records, it's usually not. So I got accused last week of providing information that I guess I shouldn't be providing, according to some of my friends out here. But ultimately, if an inmate's going to testify that this is their discipline record and I spent this amount of time, I believe we have the records to be able to prove whether that's true or not. And that's all I'm looking to submit. So what I will do is, you know, when this is over, I will look at the inmates, ex-inmates that testified, and I will provide you an accurate copy of their discipline that they actually served. So, all right? And I guess that's a problem, because all I've contended is that, you know what, please come in, tell the truth. You know?
Hang on. Let's get some order here. Thank you, Richard.
So that's all I have. Thank you.
Joe?
Any questions?
Thank you, Mr. Chairman. It is a great committee here. I have mad respect for all y'all, so you all know that. You know, this is a civil rights agenda. For some of you who don't know me, that's where I built my political hellhole on civil rights. I graduated, as well as my good brother Joe Benton back there. We graduated from SOHK, School of Hard Knocks University, and I got a heck of a diploma. And as a retired Providence cop in Southside, I spent my whole life down there. And Southside's my home. It's a great home. And it's turned around a lot. Of course, the Providence General will tell you something different. But when you go down there, you will see that Southside is a great neighborhood. I lived, I worked, and I invested down there. Everybody remembers my bar, Essence Lounge. Yeah, I put a little plug in, but it's long gone. When I was a Southside cop and went to a lot of different calls, and I started to see things differently. I did 6 years in the United States Marine Corps, and the best education I ever got was traveling this country. Seeing what they do in the West Coast, to what they do in down south, to what they do here in the East and the North. Of course, the worst ghetto I ever saw was East St. Louis, and for me to tell you, I wouldn't even want to go there. I ain't going back there. And the shootings and the killings was off the hook, and the amount of people that get locked up. So, as a young man, I end up here in Southside, and I started seeing things. And when we talk about the human brain, which is really a muscle, and you take this 18-year-old kid, whatever he's doing, bad, good, or indifferent, he's still learning, whether he's in college or not, or whether he's with me and Joe Benton at SOHK. The fact is that brain is starting to mold. You take that kid, you take that young man, you take that young woman, and you put him in prison. Okay, fine. He or she, they need to pay. They need to pay. They did something wrong. But I'm confused. Because you're going to take this 18, 19, 25-year-old kid whose brain is still developing and stick him in solitary like he or she knows what the world's all about. I don't think me and Rich over here disagree. By the way, I like sitting next to Rich. He's a good brother. Him and I go way back. But the fact is that things have to change. You've heard it numerous times for different bills that was up here, where people kept saying, changes are coming. Well, at 65, I'm still sitting down saying, well, when's it coming? What are you going to do with this 18, 19, 25-year-old man or woman? And then when he or she comes back on the street and meets a young cop like a Joe Almeida and starts talking to him, and you look at him and you're going, there's something wrong with this guy. He wasn't like this when he left the street. But when he or she came back home, that's a different person now. That ain't the same person. don't stick him or her in a cage trying to figure out what to do with their brain as they grow older. Representative Felix, I'm so glad to meet you. Yeah, I'm telling you, from all these people, if you need Joe Almeida, you call me, because I come for you. You're Pawtucket, right? Yeah, that makes us first cousins. So I'll come for you, okay? And I will fight for all my civil rights bills with this poor committee. They know. And the other thing I feel good about is when, before I got up here, did you notice the 3 people up here other than Jim Vincent? You hear Jim? Uh-huh. The other 2 were 2 young black men. Oh, he's still sitting right there. And they had a power in their voice. And that power is what I used to tell all y'all about what's going on. Well, they just proved my power. And by the way, I ain't going nowhere. I told Doc, I said, there's an old African proverb. You can either be a king or you can be a kingmaker. Girl, I'm coming for you because I'm about being, in your case, a queen maker. All right? So be understood that I'm really concerned about what goes up at the joint, at the ACI. And what happens to these brains that's going up there, and y'all need to take a look at them. Take a deep look at them. So with that, I thank you. If you have any questions, just hold on to them, go to him. Thank you.
Thanks. Thanks, Joe. Good to see you again.
Yeah.
Mr. Chairman.
Yes.
Rep, it was nice having you back.
Oh, I love being back. You know, I like to feel the
Now, you and I have to have a coffee and talk about East St. Louis.
Oh, yeah. All right, I'm down with you on that.
It is good to see you, Joe.
Thank you, my sister. I
Thank you
appreciate
for
it.
coming.
You
We
know.
miss you.
Don't worry, Cal. I'll be back. I'll be up here to give somebody some tighty whities. Don't worry, I'm back.
Oh, Edie.
Welcome back, the Honorable Joe Almeida.
Oh, thank you, my sister.
And there was a while where you were not on the south side. You were a community policeman in Mount Hope section of Providence.
She corrected me because I was a Mount Hope cop. And that's right, that was your cop. I
Yeah.
appreciate it.
Yep.
Yes,
Mhm.
Well, that Mount Hope was a good area. It was only about the size of Central Falls, but after about a couple of turns around, everybody knew me, especially when they came back out the ACI. They said, hey, man, Joe's up at Mount Hope. We got to act accordingly. But we solved some good crimes up in Mount Hope. Nothing against these young guys today, but we did it without a computer. It's called a paper and a pencil in your brain. And Mount Hope is a great neighborhood. They really love the cops up there. They really did.
Yeah. Well, I think you had something to do with that.
You know, we roll.
Jose.
Joe, it's great to see you. Obviously, I appreciate everything you said tonight. I completely agree with your testimony, and I know you made a comment that pretty much everybody here knows who you are, and I don't doubt that. But for those few people in the room who may not know who you are, I want to publicly thank you as my predecessor, serving the great people of South Providence and Washington Park for the better part of 20 years. And, COVID was weird when we came in, so I don't think that we ever got the chance to properly thank you for your service. But in addition to being a police officer and in the Marine Corps, I can now speak from experience and appreciate how hot the seat is. And so it seems as much as everybody misses you, I might be in trouble if you decide to run again.
Man.
So.
Nah. Don't worry, you my state rep, baby. I got your back. Don't you swear about nothing.
I appreciate that, man. It's good to see you.
Good seeing you.
Okay.
Yeah, I would like to. I would like to first thank the committee for allowing me the opportunity to speak on behalf of the bill that's aiming to end life without parole. I'd like to start by giving a little bit of background about myself. My name is Keith Nunes, as you mentioned. I'm 42 years old, and when I was 18 years old, I was sentenced to a life with parole plus 10-year sentence for a murder that I committed in an altercation outside of a nightclub. And that brings me here tonight. It's the main reason I'm here. And the main reason I'm here, I believe, can be summed up in a single word: redemption. Redemption. And I believe with all of my heart that all of us as individuals, that us as a society, that you men and women as leaders and as policymakers, I believe we need to believe in the possibility of redemption. And the reason is simple. None of us are perfect. All of us have made mistakes. All of us have made bad decisions. Some of us worse decisions than others, absolutely. But none of us are perfect. And I could only speak primarily from my personal experience. When I was sentenced to a life sentence at 18 years old, to be honest, it didn't take the whole 23 years of incarceration for me to realize the gravity of my bad decisions. I realized immediately. Certain things hit me immediately. Now, of course, as the time went on and I got older, I began to educate myself formally and informally. I grew, just naturally maturing. Of course, I seen things on a deeper level by then. But I'm here to say that redemption is possible. Redemption is definitely possible. It was the case in my case, and it wasn't only myself. I could speak for at least a couple dozen other men that are in the prison in my situation or worse, that I've seen the change in them over 23 years of being by their side day in and day out. So my message is very simple. The bottom line is that by ending life without parole, at least giving a person an opportunity, you're saying that there's nobody beyond redemption. You're saying that redemption is possible, and that's it. You're not automatically letting people out. You're putting the decision in the hands of the parole board. And trust me when I tell you, the parole board is highly capable. Highly capable. Any man here that's going to testify tonight, any man or woman for that matter that went before that parole board knows that you cannot go in front of that board and think you're going to BS them. Part of my phraseology. But any man or woman that's been in that situation knows that. So I'm here in support of that, and I'm here asking the men and women in this room to just have a necessary belief in the possibility that men and women can change their life around. Thank you for listening. I'm open to answer any questions.
Thank you very much. Okay, gentlemen, we've got three other people here. Jose.
Question, Chairman?
Oh, I'm sorry.
Yeah, no problem.
Jose.
Thank you very much, sir, for your testimony. Very powerful. I appreciate that. If you'd be comfortable, could you please share with us a little bit about your process and how I assume you made parole at some point? And
Yes,
could you
sir.
tell us a little bit about that?
Yes, sir. I made parole about 8.5 months ago. I'm currently working as a case manager at a nonprofit, the Reentry Campus Program. And for those who may not know what that is, it's a nonprofit that's designed to help incarcerated and formerly incarcerated individuals obtain post-secondary education. I couldn't have thought of a more poetic ending, to be honest with you. And the reason why is because education, both formal and informal, was a big, huge part of my changing process. Huge. And I could speak to the fact that the statistics back that up, that it's not just me, that it serves as a huge part of the changing process for. Education is the #1 indicator of recidivism. And with every level of education, the recidivism rate goes down significantly. So I couldn't think of a more poetic ending, but to answer your question, education was a big part of the change process, but both formal and informal, because there's a lot of things you learn from older men, from other mentors, incarcerated with you or on the street that care enough to reach out to individuals in that situation. So both the informal and formal learning is a major part of that process. And like I said, there's so many things that hit my conscience immediately. But the rest had to be fleshed out, if I'm being honest. I was still young, I was still immature. You're in that environment, your record, your trajectory is not going to be flawless. You're going to have bumps and bruises. It was a maximum security prison in the 90s. You're going to have to contend with a few things. But the learning was a major part of that change.
Thank you very much.
It's 42. Any other questions? Okay, thank you, guys. Jose Tapia, Stephen Parkhurst, and Thomas Kuntz. Can you guys all push the red button, so the button, so the red button's up? Do you see the little red light there? Yes. All of you? Okay.
See it.
Go ahead. Start with you.
Okay.
Start with Steve.
You want to go first?
Doesn't matter to me. If
It's
you
up
want
to
me
you.
to go first, I'll go first.
Sure. You go first.
I want to thank the committee for providing me with this opportunity. My name's Jose Tapia, and I'm here to represent, not only to represent, but I'm also representing change. You know, and I also want to represent those brothers that are in prison who don't get the opportunity to ever even show that they had the ability to change. 30 years ago, you know, I was a 16-year-old kid who caught a life sentence. You know, I'm 47 now, but I'm not the same person I was 30 years ago. You know, and just like Keith Nunes just said, he worked very hard to become the person he is right now. You know, I did the same thing each and every day. I worked hard and hard and hard to get to where I'm at today, you know, and it wasn't easy. I'm not gonna sit here and say that, you know, I'm a changed man, that I don't make no mistakes, because I still do, you know what I mean? I'm still growing. I'm still trying to become a productive member of society, but what I can definitely tell you is that I'm gonna work every single day of my life to become that productive member of society. And I'm not just speaking for myself, I'm speaking for those men in prison who are never gonna get that opportunity to become productive members of society because of this law, life without parole. But I can definitely tell you that there's many men out in there, just like me, who are working hard, who are trying every single day to eventually and hope that they get that opportunity again to become free and to become a productive member of society. You know, but without that change, without every member of this community saying, you know what, people can change, you know, and I'm a proven fact. I've changed, you know. I'm not the same person I was when I was 16 years old. You know, and like I said, it wasn't easy. I'm not gonna sit here and, you know, tell a story about that. It was an easy change, because it wasn't. You know, I went to prison as a 16-year-old kid, and I made a lot of mistakes. You know, but them mistakes finally caught up to me, and I was tired. I was miserable. I was depressed. And I told myself, you know what? I gotta make some changes in my life, because if I don't change, I'm gonna be stuck behind these walls for the rest of my life. You know, when that light bulb finally clicked, like Keith said, education was the key. You know, I was in my, and I'm just gonna share a quick story, because I know I don't got too much time. I could go on forever. But the problem is I can't, but I wish I could. You know, I was in my cell one day, and I was miserable. You know, I was sitting in there, and right now, me telling you, I could feel it. You know what I mean? I was in that cell, and I was miserable. I was depressed. And I had this book in my cell that I didn't read for like 3 years. For some reason, I never threw it away. It was just right on my desk. And that one day, I was sitting in there, and I was like, man, am I ever gonna get out of prison? You know, I was depressed. Again, I was miserable and stressed. I looked at that book. It was called The 7 Spiritual Laws of Success. I said, you know what? Let me try this book out. Let me read it real quick. So I read it, and it started talking about how you can manifest your dreams, your goals into reality. You know, so I said, you know what? Let me give it a chance. You know, I wanted to educate myself, so I wrote all my goals down. Education, freedom, being a better speaker, trying to be able to speak to people and trying to change people's lives. And I just started, once I read that book, I started educating myself. I started taking baby steps towards redemption, not redemption, but to rehabilitate myself. And that's what I did. You know, I worked hard. It wasn't easy, because I was used to doing things my way, but, you know, education was the key. But I'm here today hoping that all of us here can make a change. You understand? Because I know people can change. I'm a proven fact of that. You know, I'm not the same person I was 30 years ago. I was released from prison 3 years ago, you know, and like I said, I'm working very hard. It's not easy. It's not easy, because I came into a new world, and I felt like an alien. You know, I didn't know nothing about cell phones. I didn't know nothing about even driving a car, I was afraid getting on the highway and don't even know, going. I was scared to go next to the barriers and all of that. You know what I mean? So, and I'm still learning because I haven't adapted to society as the way it was when I was out here as a 16-year-old kid. But like I said, I'm working very, very hard every single day to show not only for myself, but for also my victims in my crime. You know what I mean? I gotta show them that, and I heard the bell, so, but oh, that was your bell? Oh, my fault. But I wanna show, that not just for myself that I could change, but I owe it to the victims. You know what I mean? That I can make a change, and I hope that I can make a change. Who would have ever thought, I'm in the State House, speaking in front of the committee. It feels like a dream, to tell you the truth. I want somebody to pinch me and say, you know what? I feel like I just seen the captain, Maycomber, the director, and I was like, damn. It felt like a dream. Like, are they gonna pinch me and I'm gonna wake up and I'm gonna be back in that cell? But like I said, I'm sitting in here in front of this committee today, and who would have ever thought? I'm up here trying to help somebody. I'm up here trying to help make a change. And hopefully I can touch each and every one of you and maybe change your mind. If I can't change every one of your mind, I hope I could change at least one person that could think different and could see that genuinely people can change. So that's why I'm here today. And I thank you for the opportunity for allowing me to come up here and speak in front of the committee and tell my story, and hopefully my story can help make a change.
Thank you, Jose. You're giving back too, and that's a really important part of rehabilitation. You're talking to thousands of people on that television.
Yeah, who would have thought I'd be on Capital TV? I'm on TV. You know what I mean? So I hope that, like you said, I'm talking not only to the committee, but I'm talking to a lot of people across the world, and hopefully they hear my story, and whoever feels like any kid that might, maybe be going through the channels and say, hold up, let me see what he's saying. Hopefully that they hear my story and they say, you know what? I don't want to end up like him. As a 16-year-old kid who went to prison and spent 27 years of his life and grew up in there, and now he's 47. And now at 47, I'm not saying I'm trying to catch up, but I am, because I don't know, like, how society is, how the world works, because I'm new to it. You know what I mean? So, if a kid could see it and say, you know what, I don't want to end up like that, then I did my job.
Stephen.
Oh, I have a question.
Oh, I'm sorry. Julie.
I just have one quick question for you, and really doesn't have anything to do with the bill, but what was your biggest challenge in adjusting when you were released out of prison? What was your biggest challenge coming back into society?
I'm gonna tell you the truth, right? When I was in prison, I used to watch this show on, I forgot, it was on NBC, right? And I used to watch this guy, he used to get anxiety, right? So I used to be like, damn, what's that all about? Like, he would just get these anxiety attacks, his heart would start racing, he couldn't breathe. And I think that was my biggest thing. When I came home, I couldn't be around a lot of people like this. I would get anxiety attacks. I would go down to the basement and stay there by myself, you know what I mean? And then my family thought that I was trying to avoid them, when in all actuality, it wasn't that. It was just I was getting these anxiety attacks, and I needed to be by myself and relax, and then I could just come back upstairs. But I would say that was probably like being around a group of people, you know what I mean? I think that was my hardest thing.
Thank you.
Thank you.
Thanks, Jose. Stephen.
So good evening, and thank you for having me. My name is Thomas Kuntz. I'm the Reentry Program Manager for the Center for Teen Empowerment in Boston, Mass. I'm here to support the Life Without Parole bill, excuse me. And I have good reason to support the bill. I too was serving a first-degree natural life sentence in Massachusetts. I was sentenced in 1992. I walked into Walpole Prison, and I had a decision to make at that time. I can remember my cousin approaching me saying, listen, you sit at that table, you protect that table, you protect that chair. You don't let nobody take that chair. And that was the mentality back then, because Walpole was very notorious. However, I wanted to make a change. I wanted to do something different. I wanted to get my college degree as I wanted to do on the outside. So I made a different choice. I decided to go into UMass, Massasoit College, start educating myself. I started signing up for programs. I eventually moved on from Walpole to MCI Norfolk, which allowed me to establish myself a little bit better with more programming. I eventually got into a program called Second Thoughts. I was counseling young men that were coming in from the DYS system. I did that for 27 years. I eventually got with a few men. We created a restorative justice program behind the wall. I got my degree behind the wall, and I actually prospered right in my environment despite all the negative things that were going on. And I wasn't the only one that was prospering in there. There were many men that were in there that were prospering with natural life sentences, no hope of going home, but we never gave up hope, and we wanted to change. We wanted to do the right thing. And while other people were going to the whole back and forth, I was persistent in the work that I was doing. I was so persistent that just last year the governor commuted my sentence. And as you all probably know, that doesn't happen too often. We were the first, it was two of us, myself and William Allen. We were the first two to get their sentences commuted in 25 years. And when I went to that board, and I don't know why I'm so nervous here, because I've been in 3 different boards. I had to go to the advisory board, I had to go to the, before the governor, and then I had to go to the governor's council. For 10 hours I sat and was questioned, and they deemed me worthy of coming home. I shouldn't be sitting before you today. I'm a living miracle, and I'm a story of redemption. I'm here to tell you that you can change in prison if you're putting the work in. So I truly believe that if you're doing the work and you're rehabilitating yourself and being a positive person in prison, I believe there should be the opportunity to come up for parole. And that's what I was given. It'll be a year, April 19th. I came out with a job. I'm now helping young men that are coming out of prison, ages 16 to 25. I'm helping them to get jobs. I'm doing restorative justice circles with them. I'm just helping them to become the men that they can be by supporting them with mentors. And again, there are numerous other men behind the wall. And I may be in Massachusetts, but I'm sure it's reflective here in Rhode Island as well. I had the privilege of serving time with one of the men that came out of Rhode Island, which is Steve Quinlan. And again, not condoning the crime, but that man is doing an exceptional job behind prison walls in Massachusetts. He happened to work with me for about 10 years in restorative justice programming. On the planning team, we brought 9 programs to that prison, which we brought in prosecutors, we brought in judges, we brought in community members, survivors who said that they have healed as a result of coming behind the wall and seeing men take responsibility for their crimes. And that just doesn't happen. I served 30 years in prison before I was released last year. 30 years I was constantly working, trying to make myself a better person. And obviously, Governor Baker, a Republican governor, must have seen something different about me. It took a Republican governor to do what other people should have done. So kudos to Governor Baker. I'll give him a shout out even though he's not in office anymore. But I appreciate this opportunity so much, and I know I speak for a lot of men in Massachusetts, in Rhode Island, all over this country, who are putting in some serious work and really are the backbone. The lifers are the backbone of the prisons. They're the ones that's bringing these young ones to the side, trying to push them to the schools, because that's what I was doing. I was tutoring them. I was, taking them to the side, putting them in the programs. Let's do this, let's do that. That's your lifers. That's who's doing the work. But that's who's keeping the public safety in the prisons. And so when we come out, some of us, it was a one-time incident. I was in the Marine Corps, home on leave when I committed my crime. Right? It's a one-time thing. Natural life sentence. People are not beyond redemption. And I don't care if it was 2 or 3 times. I've seen people that have been in and out and finally got it and finally woke up. People are not beyond redemption. That's all I have to say. Thank you for your time. I appreciate you hearing me. I am way past my bedtime. And, I need to get back to that.
Chairman.
Stephen. Oh, I'm sorry, go ahead.
I just want to, it's past my bedtime too, but listening to these stories makes it all worthwhile. So I just can't say enough good things about these stories. Are so inspiring. So I hate being up this late, but thank you.
Thank you.
Stephen Parkhurst.
Thank you. I'm incredibly nervous as well. This is my first time speaking in front of a committee. I would like to thank Chairman Craven. Don't know if you remember me.
I
but,
do, yeah. Long time ago.
It's a great opportunity right now, because back then, I didn't deserve to sit here. When I was your client, I didn't deserve to sit here. So it's an honor for me to sit in this chair right now and to address you and to honor you and to address this committee. So thank you for having me tonight. I'd also like to say out loud before I begin that I know every time that I'm in the newspaper, every time I speak publicly, that there's a potential that I hurt somebody's feelings, that I committed great harm 30 years ago, and that I need to honor that and say that out loud before I ever speak publicly. With that said, again, my name is Stephen Parkhurst. I am presently the program coordinator at Freedom Reads in Hamden, Connecticut. We travel the country and we go into prisons nationwide and we install micro-libraries into housing units for folks on the inside. So I want to say out loud, based on everybody's testimony here that's formerly incarcerated, how education changed their life, that freedom begins with a book, which is our motto at Freedom Reads. I'm also on the legislative policy team at Voice of the Experience in New Orleans. I don't know if some of you folks remember Bruce Riley. I know you do. And he told me to say hi tonight, Bruce Riley. But Bruce was a mentor to me and showed me how, you can take the steps getting out to change your life and positively impact your community and be a mentor to somebody. Also, I'm a juvenile lifer who served 30 years in prison. I am 4 months released. First of all, I want to honor you so much, Ms. Casimir. I really want to say out loud, I can't even look at you without getting emotional, and thank you so much for educating as many people about the brain science of folks 25 and under. My second chance is because I was 17 and a half, right? That's it, Mr. Craven, because I was 17 and a half. A few months separated me from never going home. And in fact, I had a de facto life without parole sentence. Back in 1992, I committed the regrettable and shameful crime of murder. I killed a 20-year-old young man at a teen drinking party in North Smithfield. I was the first trial in Rhode Island's gun court in 1994 in front of Judge Bossier. I saw her on the newspaper, the front page of the Providence Journal, right before I went to trial, Maximum John. And I was scared to death. And I remember going in there and I was represented by the late John Hardiman, who did his best to tell me I had no idea how deep in it I was. And I can tell you, at 17 years old, I didn't know. I'm here to talk about the abolishing the life without parole bill, but what I'm really here for is to talk about second chances. Right? So we know in 1992, all the super predator things about juvenile lifers, juvenile offenders, and I deserved it. I deserved every single bit of that life plus 45 years when I was 17 years old. I'll be the first one to tell you that. And I walked into that prison, and I'll tell you, some of these guys will say, I walked in that prison and I knew right away, I got it, I knew I need to start to change. I knew the gravity of this stuff. I didn't. I was 17, I was 18, I was 19, I was 20, I was 21, 22, 23, before it really started to sink in. So that brain science was literally happening in real time for me. And you called me around 25, Mr. Craven. And I was still trying to figure it out. And all I really wanted was to go home. And I knew in that moment I was never going home. And I was grasping at every single straw that there was to grasp at. every post-conviction remedy that there was, and I apologize for wasting the court's time, but I was wasting the court's time because I just couldn't wrap my mind around never going home. You know, the guys that are up here now, Jose, Keith, Mario, really good friend of mine. This is a cohort of folks that kind of came in the early 90s, and we championed each other in that prison yard. And I'll tell you, I grew up in front of a lot of these officers, and, you know, Officer Maycomber was a rookie. Like, I rookied him in, like, I had already had a few years in before he came in. And Mr. Fruccio, and they could probably tell you better than I could or anybody else, yeah, that he wasn't that bright back then. He still had a lot to do to figure it out. And I can tell you that folks that are doing these insurmountable sentences, there's a lot to figure out. There's a lot to figure out. And the only thing that I've ever encouraged people, and they've encouraged to me, was to wake up tomorrow, do it again, go to school, find an education in there, find something. And every little affirmation of some sort of work that I put on the inside gave me some sort of hope that there'd be some, maybe, and I tell Keith this, right? Like, we're giving away our secret right now, this 70-30 of, like, you know, on any given day, it's like 70% of, like, really good heartedness and hard work, but 30%, I just really want to go home, and I just want to impress the parole board, right? And I got a bachelor's degree on the inside. I get an associate's degree. Thank you. Thank you. And to every single person that it had been over 30 years when Ray DePasquale, the president of CCRI, came up to the maximum security prison and conferred an associate's degree to me. And it was more important for me to see all the other guys get, to see that and to say, like, why not get it in max instead of medium, right? Why is this such a disciplinary building? And a month later, they moved me to medium. So I get when they talk about solitary confinement and all this stuff going on there, because I've seen a lot of things go on in prison. I wish there's a lot of things I could unsee in that prison. But I can tell you that the guys that are doing life without parole, they walked that same yard with me. They took the same classes with me. They got the same education I got. We read the same books. I don't know if you know about this prison thing that, you know, when a newspaper comes in or a book comes in, it's really good. We write the cell number down on the inside, who got next, right? And this is a story I tell at Freedom Reads all the time of how books are so important. And you knew a good book because when you open that up, there'd be like 20 cells in there of who had next on that book. And all them guys that you're considering tonight, you know, I know there's only like 24 of them, but all the ones that I did time with from 1992 on that are in maximum security, you know, I've done time with. I've shared books with them in there and walked that yard, got an education, went to programming with. Sometimes we were the first line of defense, like he said, the lifers. When somebody's having a bad day and they're like, Steve, I'm going to go X, Y, Z, and I'm like, come on, man, like let's do something better, man. Let's think that out. Let's, you know what the consequences of that are. And somebody mentored me in that way, the Bruces of the world, right? The Andres Adaraga that did 6 years, went to Yale University and got a law degree. You know, all these folks that had come out of there, the Noah Kilroys, that's an attorney here in Providence, that I stopped by before I came in here today, you know, because I honor his story so much. I'm going to take my LSATs in 2 weeks because of these guys, right? And it's about second chances, Mr. Mayor, right? And you asked about what the process of the Rhode Island Parole Board was. And I can tell you, Ms. Pisatoro was tough. In 2017, she looked me in my face and said, "You're never going home."
She was wrong.
She was wrong. In 2017, I peacefully petitioned for my own release by bringing a federal suit into court against then Governor Gina Raimondo because I was afraid. I was afraid I would never go home. And I said, you know, they're gonna bury me under the prison for this. I'm making a mistake doing this. And I saw all these other juvenile lifers around the country getting relief, and I was like, you know, I think I get it though. And I went in front of that board, and they were like, no, you don't really get it though. And they gave me a 9-year hit. Reconsideration, that's the slang of prison for a reconsideration date. Gave me a 9-year hit. But told me to my face that I'm never coming home. They said, when you come back in 9 years, they'll probably give you another 9-year hit, but I won't be here to see that. And all I did when I went into that hearing was pat myself on the back of all the hard work that I had done, all the degrees I got, all the dogs I had trained in prison. And I said, you're doing good, Steve. But really what it was about was when I went in the second time after the judge, pardon me, after the parole board reconsidered their guidelines to make expanded consideration for juvenile offenders. And I was given a second chance. And I went in front of that board, and the first thing I said was, thank you, Ms. Pisatoro. I would just like to say one word, humility. Because I came in here the last time and I patted myself on the back for all the accomplishments. I told you they were accomplishments. And how badly that must hurt people's feelings that think about crime victims. And I just want to say that I learned over the last 4 years how stupid I was. That was a powerful experience for me, and I learned a lot. And really what I just want to tell you today is not about me, but about my family, what I put my family through. And by a unanimous vote, the Rhode Island Parole Board granted me parole. And as you know, I had a consecutive sentence in the state of Connecticut. I served 4 years. I'm presently on parole. I have an Apple Watch around my ankle right now from the good state of Connecticut. I am on a parole pass from my parole officer who values pro-social activities like this. Right? I'm no different than these other guys that they don't get a second look. And they haven't got a second chance. That's all I want to say. Thank you.
Thank you.
Thank you.
Very powerful, Stephen, but you're the only one who can pass that on, because you're the only one who lived it. And that's the most believable part of all, is that you lived it.
I apologize to you as not being a great client 20 years ago.
No. You don't have to apologize to me. We both learned humility in the last 20 years.
I'm sure. Thank you so much for your
Sure.
time tonight. Thank you.
Okay. Thomas Harvey, Christopher Robinson, and Mrs. Medeiros, would you come up? He needed me to get rid of the Connecticut consecutive time, so I did. Thomas?
Thomas. Good evening, respected members of the committee. I am here today in support of Bill 5149 to end life without parole in the state of Rhode Island. My name is Thomas Havey, and I pride myself in being a living proof example of rehabilitation and second chances. I served 13 years of my 30-year sentence at the ACI, and am currently serving the remainder of that sentence today on parole. Since getting out, I have become a proud father and a first-time homeowner. I've become a successful dog trainer and manager of a local board and train facility. While incarcerated, I was a member of the Need Service Dog Program, which taught me the skills I needed to excel on the outside and sparked my passion for helping dogs that have been labeled aggressive and are similarly looked down upon by society. This is just one of many instances where I applied what I learned while incarcerated in my everyday life. I was recently invited back to medium security as a guest speaker at a graduation ceremony. My sole purpose was to inspire those men, to provide them with hope for a better future, and to show them that it's possible to succeed in this world and to live a happy and meaningful life after incarceration. I was fortunate enough to have a second chance and the opportunity to prove to a parole board that I spent my time while incarcerated rehabilitating and bettering myself, an opportunity that currently isn't available to all. I would like to emphasize that I am not an exception, nor are the men and women present today in support of Bill 5149. There is a strong community both inside and outside those walls of people who support each other's efforts in the shared goal of being a productive member of society. I credit the individual I am today to my time spent behind those walls and those who supported me. My truth and the truth of so many who are still awaiting their chance to prove to the world that we accept responsibility, are accountable for our actions, and are remorseful for what we have done. I and those I have met during and after incarceration have put in countless years of self-change and growth. Nobody here today is looking for a get-out-of-jail-free card. On the contrary, there is countless men and women rigorously working to right their wrongs, going above and beyond to prove their worth, knowing that they will face adversity but are willing to overcome. As Representative Edwards mentioned earlier, we have a very competent parole board, fully capable of assessing each case individually if given the chance, which is what this bill aims to do. I'm here today just like the rest of these guys who just have spoke before me to try to give you guys a glimpse into second chances and to rehabilitation and to some of the success stories that are out there. I've actually shared a cell with Jose Tapia and Steve Parkhurst in my time incarcerated and was able to have great mentorship while in there from those guys. I worked with Keith Nunes in the dog program, even though it was short-lived, but he worked with me in training service dogs. There is a very strong support system amongst the formerly incarcerated and the currently incarcerated. There's a strong core group of guys in there that steer that ship, that preach self-change, that preach rehabilitation, that look to improve on their lives daily and improve their quality of life, even behind those walls. And I'd just like to thank you for allowing me to speak here today on behalf of this bill.
Thank you.
Good evening, ladies and gentlemen of this committee. I would like to thank you all for... Red light on. Red light is on. Sorry.
Bring it a little closer to your mouth.
I would like to thank you all for this opportunity for inviting me to your state. I am actually from Massachusetts. I am currently on a lifetime parole, serving a second-degree life sentence for the murder of my stepfather. I was released this past February, so it's been just a little over a year for me. I would like to begin this because so much has been mentioned about redemption, books, knowledge, education, by referencing probably one of my favorite authors of all time, Viktor Frankl. And in his book, Man's Search for Meaning, he mentions the one thing that allowed him to survive the concentration camps, and that is the Latin term vae victis, which translates to woe to the vanquished. And he says that something that allowed him and so many to survive during those horrible times was the promise of hope. Because what are we as human beings in our future if we have no hope for a future? We might as well just fall down and die and just allow what's going to happen to happen. So when I look at second chances, I look at redemption, I think about all the 16, 17, 20, 23, 25-year-olds, men, women, children, who are sentenced to a life without parole sentence. What hope do those individuals ever have for the possibility of a future other than a prison wall, a cage? If they have no hope, why would they ever want to be responsible? Why would they ever want to be accountable for their actions? But when there is a hope and there is still humanity given to them, where they're not treated as a monster, they're not thrown away like garbage, they can thrive. They can learn, they can adapt, they can evolve to know what they did wrong, to take responsibility, to be accountable, to try to be functioning members of society, even if it's a society that doesn't want them. And the work that we did with restorative justice, we saw that not only did we create victims by our actions, but we created victims within ourselves, because everybody is accountable for what happens in a society. And I believe that no one should be just thrown away for the worst act they've committed in their life. Are you a baker if you make a single cake? Are you a seamstress if you fix a sock? So why should you always be remembered for the one horrible action you've made in your life if there's still the possibility that you can change, that you can be accountable, that you can give back to a community and not just be a wasted life thrown away and never given the chance to show that you are something more than the worst act that you've ever committed in your life? I was given my parole the first time going to the board. And in Massachusetts, a lifer for a second degree has a 6.7% chance of receiving their parole the first time. And I was able to get it because of individuals who are serving life without parole sentences mentored me when I first came into the system, because they did the riots, they did the fights, they did the hunger strikes, and they taught me that I don't need to do that because they already did. That way of the system doesn't have to exist anymore. That it's not us versus the correctional staff. That mentality doesn't have to exist because everybody wants to exist in a loving, compassionate life. There can still be prejudices, there can still be anger about the circumstances, but it doesn't mean that that has to be all that exists. So I was mentored and I was shown the right way of doing it. I was pushed into school, I was pushed into the trades that I didn't want to do. I want to go play handball, I want to run around, I want to be a kid. But the older gentleman that mentored me showed me the right way of doing it. And they're still in prison. And I acknowledge that I can have no contact with them because of a violation of my parole, but that's my family. I grew up as my brothers, as my uncles, and almost like my father figures. And I would love to see them come home one day when the time is right for them, when they've healed, when they've become accountable. Because nobody should just be left to rot in a hole. If they truly want to change and they want to grow, why not give them a chance? Thank you.
Thank you. Thank you. Carolyn?
I just want to start by saying that this bill, I did an edited version because we assumed in the beginning when Rep. Edwards said that he was editing it. Now I go back to the original testimony. But I want to make a point of saying that the Attorney General has stated that there are 30 individuals that are on the list for life without parole. Not life sentences, life without parole. There are 30. I submitted the list of 23. Rep. Edwards has 24. All matter public record, the court cases, articles, some of the news stations' follow-up stories. Life without parole, not life. I have advocated for victims of violent crimes in Rhode Island since 2004. A necessary evil of testifying and advocating for these victims is the necessity of addressing the heinous crimes and names of those who perpetrated those crimes Therefore, it necessitates I mention these individuals periodically. If there were a goal I could achieve tonight through testimony, it would be to amplify the good referring to the good souls from the list of victims I will highlight. I would attempt to extract anything else negative, such as their executioners and the heinous, violent, perverse acts these criminals carried out on their victims. Lives were taken, beautiful, innocent lives, mothers, fathers, sons, daughters, grandmothers, grandfathers, grandchildren, nieces, nephews, wives, husbands, cousins, friends, and members of loving, supportive communities throughout Rhode Island. The Alliance for Safe Communities moves forward in 2023 with a new and lasting mantra. Say their names. Kristen Jorge, Kelly Anderson, Savannah Smith, Lindsay Burke, Kendra Hutter, Jean Robinson, Kelly McGinty McManus, Michael Batista and Raphael Edwards, Carlos Chang, Rosario Hilario and their 4 children, Mild Day Hilario, Margaret Duffy Stevenson, Pamela Plant, Jenny Lee Bailey, Jason Burgess and Amy Shute, Sanjeev Patel, Gabrielle Medeiros, Angela Spence Shaw, Ernest and Alice Brendel and their 8-year-old Emily Brendel. Detective James Allen, Barbara Raygoso, and Dermas Rodenzo. This bill sets a precedent that the most heinous crimes committed will not be met with the most serious consequences. We do not have a death penalty in Rhode Island, therefore there will be no ultimate deterrent existing. This is not a second death sentence as referred to by Representative Edwards. Plea hearings allow the defendant actual opportunities to overturn their convictions and seek relief from their life sentences without parole. See its separate and attached sheet. We are lowering the bar for one's responsibility and accountability for the most heinous of crimes committed. This bill, as passed into law, cannot deny that it is attempting to save one, as Representative Edwards claims, as a chance for all 29 others would not be eligible for review of their convicted status, life without parole. The risk of embarking on such actions is quite remarkable given the window of opportunity for possibly devastating consequences. Parole boards do not replace judges and juries, nor should they. There are many instances our parole boards in Rhode Island have simply not executed the right decisions. To undo the decisions by a judge and or a jury is an affront to justice for the victims and their loved ones. The result for many victims and their family is the reality that the promises made will become the promises broken. Matching reduced sentencing criteria elements on this bill to actual cases on the court articles pages proved to be quite disturbing. Kidnapping a minor, death resulting, rape, beaten to death, 8-year-old Savannah Smith, robbery of the owner, lessor, or occupant of a motor vehicle, injury, death resulting, that's carjacking, Jason Burgess and Amy Shute, that were execution-style murdered. As I said, these were life without parole and are the most heinous crimes I've ever seen in this state. Using a firearm when committing a crime of violence, Detective Alan Sanjeev Patel, Jason Burgess, Amy Shute, Gloria Medeiros, Barbara Raygoso, and Dermos Rodenzo. The reduction of the life without parole sentence for a criminal acting with a firearm regarding injury or death versus our current climate of attempts to confiscate guns from law-abiding citizens does not escape the scrutiny of its irony. Alliance has also opposes the elements of the bill regarding eligible work release or furlough applied to the category of life without parole. Health and age of the criminal being the qualifying factors. May we refer to the cases we have presented as comparison and contrast. Savannah Smith's age of 8 years, victim of kidnapping, rape, and murder, was not relevant to her executioner, Joshua Davis. His literary boasting he enjoyed his catch demonstrates that fact. Emily Brendel's age of 8 was not relevant to Christopher Hightower when he kidnapped, drugged her, and buried her in a shallow grave upon her mother's dead body, whom he previously killed with her mother, her father and her mother.
Excuse me, Carolyn, did
Yep.
you submit that letter?
Yes.
You did. So I'm going to ask you if you could try and wrap it up.
Okay.
We have about 70 people
I'll do
that
it
still
quick.
haven't
Angela
testified.
Spence Shaw, 66 years old. Jeremy Matoika, I don't think he cared when he beat and raped her and disposed of her body. She was a grandmother. That's age. 17-year-old pregnant Jenny Lee Bailey was simply in the way.
and needed to be gotten rid of by Pacheco. Finally and reluctantly, I must obviously question the list of convicted offenders with parole sentences, who amongst them, if the bill would currently pass, who would be eligible on the list of 30? It's a matter of public record, and actually it should be known. It pains me to list. I won't say all the names because we're cutting out time on, on all these. But you know what? In closing, I ask the names of the victims resonate in our memories tonight. We wouldn't be here if not for the loss of their lives, and that's of paramount importance. Say their names and remember them, for history is known to repeat itself when we forget. The consequence of this bill attempts to conveniently obliterate the memories of these victims.
Thank you very much. And thank the three of you for your testimony. It's very compelling, and thank you for your personal stories. So I'm going to ask everybody, we got about 70 people in this room. We're going to go to a 2-minute limit. We have to. It is now 11:30. We'll be here till 2 o'clock in the morning if we keep going. And it's for you and for us, right? So I'm going to call the next 3 witnesses. Thank you. Kalia, am I saying your name right? What is it? Janiga? Oh, sorry, I just killed your name. I'm sorry. Come on up. Aaron Regenberg and Alexandra Bailey. Please, we're going to have to try to look at all the people that are still here. So I know everybody has a lot to say, but we have heard a lot already. So thank you. Go ahead. Please state your name for the record.
Shanika Isom.
Shanika. What's your last name?
Isom.
Isom.
And mine is very short because I'm nervous and I really don't like to talk to people. So.
Well, then go right ahead.
Okay. Mine is written as well, too. So.
Oh, okay.
My name is Shanika Isom, and I'm the daughter of Golel Oliveira, an inmate here in the medium security prison. Sorry, I'm nervous.
Just move the mic towards you just a little bit.
Yeah, move it closer. That's the best bet.
My father was put in jail 27 years ago when I was only 6 years old. He was given life plus 40 years, although he was just one of 5 other people in his case. The other 4 in his 5, sorry, getting emotional. My father is the only one left.
Oh.
Left in prison. He was given the most time because his judge said that he was in rehabilitative. In those years, the father I knew was the one who would call me every weekend and help me with my homework and constantly make me feel loved, even though we were separated. And now as a grandfather, he calls just to sit on the phone and listen while my daughter plays her viola in her orchestra. My father has been a good model inmate, completing classes and programs and not getting into any trouble. The point of prison is to help inmates and for them to be productive members of society. If you give people excessive years without the possibility of change, then what is the point? My father went in front of a judge who believes he deserves another chance after proving himself for all of these years, but unfortunately his hands were tied. By passing this bill, you are allowing other judges you trust after so many years just to take a second look and give a second chance to those who are deserving.
Thank you. That was very good. You did a great job.
Thank you.
Aaron?
Thank you, members of the committee. It's nice to be back in this room to support Representative Felix's really important legislation on solitary confinement reform. As some of you may remember, in 2016, as a then rep, I introduced a bill very similar to House Bill 6161. And House leadership at the time decided that we shouldn't pass legislation telling folks at the ACI how to do their jobs, and instead community advocates should work with the DOC to make any changes that were needed collaboratively through administrative action. So with that goal in mind, I served as the chair of the study commission that was referenced earlier in this hearing. For well over half a year, leaders in the fields of corrections law and policy, mental health, psychiatry, clinical social work came together with the leadership of the department and the Brotherhood to study the impacts of long-term solitary confinement and attempt to develop recommendations for safe and actionable administrative policy reforms. It was a long effort, it was laborious, it was intensive, but over the course of months, on a range of issues, it seemed that the experts and DOC leaders were able to come to an agreement on a number of important recommendations. If it were possible to study and collaborate and trust in the DOC to be able to solve the problems that we identified through that process, then that commission and its aftermath would have solved the problem. And yet here we are 6 years later, and long-term solitary confinement, periods of time that I don't think it is unfair or overly dramatic or hyperbolic to describe as cruel and inhumane, are still being meted out to Rhode Islanders. The gentleman from the department mentioned a longest period of 250 days and a second longest of 45. I don't know the accounting exactly behind that. I imagine perhaps that when one's status shifts, that they restart it. The real question, I think, is how long has someone been in high security? And the Center for Justice is in contact with multiple, more than half a dozen individuals at least, who have been in high security for years, multiple years. There's an individual who's been there for 4 years. That's restrictive housing, as you heard described, for multiple years. Some of those individuals have engaged in serious self-harm. So it's nice to hear that there have been some marginal changes and improvements that have come from this process. The core issue, that there are people who are being held in inhumane standards for periods of time that melt your brain, has not been resolved. And that's because there was no legislation. This bill would codify into law the reforms that experts, community members concluded back in 2017 were necessary to increase safety in our prisons, improve prisoners' health outcomes upon release. The experience of the last 6 years, I think, shows that legislative action is necessary. And I would ask this committee to take a stand and do what you can to try to make sure that there is actually a mechanism to stop what is, I think, unimaginable for any of us or our loved ones to have to go through that is happening every day.
Thank you, Aaron. Alexandra?
Good, very late evening.
Yes.
Madam Chair, and thank you, honorable members of the committee. My name is Alexandra Bailey. I'm the senior campaign strategist at the Sentencing Project. And you're going to hear from other experts from my organization, so I think what I'm going to talk about is going to be personal. And I share this with you all because I have found Rhode Island legislators to be very humane and exceptionally kind. I was 9. I mean, look at my face. I was 9 the first time I was victimized, and the crime was heinous. And the person who did it is serving a life without the possibility of parole sentence. And I do not believe that people should die behind bars. And then I was victimized again as a grown woman. I take seizure medication every morning from the attack that I suffered. I'm lucky to be here. And I don't take anything away from people who've survived terrible crimes, because I'm one of the lucky ones. I survived. I'm above ground. And I know the difference. And I know what it is to suffer the anguish that makes you crumble in on yourself. I know what that rage feels like. I know what it feels like to think you can't forgive. But let me tell you, the day that I forgave, I went from a life of anger, depression, self-harm and suicidal ideation to the woman that you all now know. A woman who is happy in her life, who is strong, and yes, I carry that pain every single day. But I am not going to allow people to think that every single survivor comes to the same conclusion, because they don't. I was told, I was promised that this was going to make me feel better, that this was going to protect me, that this was what was going to heal me. You want to know what healed me? Talking to my perpetrator, who did exactly what so many people testified here did. First thing is, I'm sorry. I'm so very sorry. He's a much older man now. I'm a much older woman. And forgiveness is not for everyone. But that does not mean that the state should use the walking death penalty. The cause of justice never comes down to one person, but to what is best for society overall. And what is best for society is always going to be rehabilitation, coupled with responsibility, coupled with the restoration of people who have suffered violent crime. There are a lot of Black and brown women specifically whose stories of victimization and survivorship get ignored. The lack of investment in my community over time, the lack of mental health resources, the lack of a place for him to go after, as it turned out, as I learned, he was victimized, is why I was victimized. If you want to spend money, if you want to spend the millions of dollars you're about to spend on the multitude of seniors that you have behind the walls, people who are paralyzed, people who have IQs less than 60, you even have an innocence case in there. You want to spend that money? Don't. People used to say my name. People used to say my name. I got weaponized against my own family member. Oh, and let me be abundantly clear. My childhood rape was incestuous. I'm lucky to be here. I take nothing away from what people survived, but let me tell you, forgiveness is divine. It is absolutely divine, and I ask that you all not offer anybody a get-out-of-jail-free card. I am not asking that you release people tomorrow. Nobody here has said that. But I'm one of the people who survived this. And if that case came up, I'm before the parole board tomorrow. And if they wouldn't hear me, I'd stand outside with a sign. I believe in second chances. Rhode Island is a state that is 14% Black and brown. 40% of your lifers are Black and brown. The system not being able to go back and review itself is not a good system. It's why this state never used the death penalty, because you knew making that mistake is something that this state was never willing to do. It's the hope state, and I have loved this state for that. I love this state for that, and I hope that you continue with that tradition and offer a glimmer of hope to people who are serving extreme sentences. Thank you.
Thank you, Alexandra. That was tremendous. Thank you very much. Next is Amy Fettig, Rabbi Howard Voss Atman, and Altman, Jose Carrera? What? Oh, okay. Ayman Abdul. He had to leave. Okay. What's that? Bradshaw Reese. Ah, come on up. Amy, you want to get started?
I sure do. Good evening. Thank you. to
And
the
let's try and
honorable-
watch the time, because
All right.
we've been told from the powers to be upstairs somewhere.
Keep it going. So, honorable committee members, thank you for having me here today. My name is Amy Fettig. I'm the executive director of the Sentencing
Amy, is
Project.
your light on?
It is. Yeah.
Okay, pull
Are
it
you
closer.
hearing- Okay.
Pull it closer. There
I'll
you go.
start again.
Yeah.
Amy Fettig. I am the executive director of the Sentencing Project, which is a Washington, D.C.-based research and advocacy organization founded in 1986 to promote fair and effective criminal justice policy, grounded in the facts and data. And we are here today to support H5149. Tonight, even at this late hour, I'm very happy to return to Rhode Island after spending over a decade working with youth in the training school and on conditions of confinement in the ACI. And what I learned during those years working in Rhode Island is that this is a state that has leaders and citizens who support sensible and humane reform of their justice system. And this is the approach that we find in H5149. It is a sensible and humane reform, and that's why the Sentencing Project supports it today. There are many sound reasons to support this bill, but with the short time that we have, I want to focus in particular on the fact that there is no public safety justification for life without parole sentences. Public safety requires that we focus our limited resources on what actually deters crime. And we know from decades and decades of research that it is the certainty, not the severity of punishment, that actually does this. So extreme sentences, like life without parole, are not effective ways to prevent crime in any way. Moreover, ending life without parole in Rhode Island would not guarantee that any individual actually comes back to the community. What it does is ensure that they have to demonstrate a clear lack of risk to the community in returning home. But H5149 also offers hope to those behind bars and the incentive to comply with correctional regulations and pursue rehabilitative programming. And this promotes better outcomes for everyone. But life without parole sentences are also unnecessary for incapacitation.
You're going to have to try and wrap it up,
All right.
please.
I want to focus on what we know in criminology to be the age crime curve. And simply put, that's the fact that people age out of crime. Most crime is committed by people in their late teens to mid-20s, and after that it falls off dramatically. This is true in the United States. It's true across the globe. It is one of the most well-established factors in criminology today. And you heard about it again and again from
Yes, we have.
individuals
So
who came back.
thank you very much. I'm sorry to cut you up, but we really have to get this thing
I
going.
understand. Thank you
Thank
for your
you.
time.
Rabbi?
Hi, I'm Rabbi Howard Voss-Saltman, spiritual leader of Temple Habonim in Barrington, and of course, thank you for enabling me to speak tonight. I want you to know how on this eve of our holiday of Passover, how extraordinarily inspiring the stories that we've heard this evening are. Stories of redemption, which is what our holiday is about, and the stories of liberation, that is what they expressed. To think that our friend Stephen, who was up here just a few minutes ago, whose age in his 40s, would spend 30 more years instead in prison, behind bars, instead of assisting others in social justice work. 30 years and God knows how many millions of dollars to spend to do that, and at the same time offering him no hope whatsoever. A life lived completely wasted. And imagine the gentleman who was here just a few minutes ago who spoke about Viktor Frankl's Man's Search for Meaning with such eloquence, and how he read that book and it taught him that suffering is all about how you respond to suffering, and now he's helping others. I taught that book last semester to my congregation. And here he is, helping others. Or the gentleman who was here first, who spoke about being 42 years old, and now is helping other former inmates try to get their life back. Imagine he would spend 30, 35, 40 more years in prison. Why? Why? Our scripture, and Judaism in particular, speaks about how critical it is that we are able to seek forgiveness, that we are able to seek the pardon of, in this case, the state, so that we might not be defined by our very worst moments. And in our religion, on the Day of Atonement, which is Yom Kippur, it is the central tenet of Jewish life, which is that we can be forgiven, we can be given another chance, we have the opportunity for redemption. I know I'm over time, and I know that this is late, but it's so, so important to hear the words that and the stories we've been hearing tonight, because they speak to the kind of society we want to be in Rhode Island and in this nation, which is not to punish for the sake of punishment, but to seek people's rehabilitation and to give them hope and a second chance. Thank you so much.
Thank you, Rabbi. Next.
Good evening, respected members of the committee. My name is Dr. Brashani Reese. I hold a doctorate in forensic psychology, and I'm a trained restorative justice facilitator. I know many of you well at this point, but something I have not shared, I just want to share really briefly with you, which is that the reason that I went to restorative justice and I sought out restorative justice is because in 2009, I became a member of a group that I never asked to join. I'm a survivor of attempted murder. I sought out restorative justice because the prosecutor in the case had promised me that prison was going to bring me peace, contentment, all of the things that are supposed to be, that the monster is gone and away. I practiced restorative justice inside in 7 different prisons for 4 years, and I want to read you a very abbreviated version of a public apology written by a man inside. This is a public apology written by Stephen, who is serving life without parole. He is 42 years old and has served 22 years. Far too long I have shied behind the curtain of shame and regret, seeking false comfort in a complex web of denial and deception. In the many years since I had murdered Mike and Raphael, I have been haunted by the reality that I cowardly betrayed my 2 friends while trying to impress others. But today I stand here ready yet ashamed to admit that I murdered these poor young men. I devastated their families. I am sickened to know that I was capable of such horror. I regret what I have done, but regret will never bring them back. Regret will never erase the past. Because of me, these 2 young men are gone forever. Because of me, they are dead. I'm sorry. I'm sorry I murdered them. I'm sorry that I robbed them of the chance to live, the chance to grow, the chance to change, the chance to explore their great potential. I robbed them of the ability to see the world, to start a family, simply to exist. I robbed them of everything. I'm sorry that their mothers, fathers, and stepfather can never again embrace them, never again look at them with pride, joy, and happiness. I'll end by saying, in no way do I justify or glorify or condone my horrible actions. I take full responsibility and accept the consequences that society has imposed upon me. I'm sorry. Thank you for your time.
Thank you. Thank you, Doctor. And thank you all for your testimony. Next is Rabbi Jeffrey Goldwasser. Oh, he did? Okay. And Linda Witka. Is she here? Linda? Okay, come on up. Will Ellis? Is Will Ellis here? No, okay. How about Natalia Friendlander? Yeah, Natalia's here. Okay. And Maureen Morency? Yep, she's here. Okay. Come on up. And Linda, you want to start? No?
Me?
Are you Linda?
I'm Raquel.
You're what?
Raquel.
Raquel.
Yes, sure.
Sure.
Thank
I don't
you.
even see Raquel on here.
Raquel, any bill that any one of you want to testify on, now's your time.
Sure.
Thank you so much. Well, good evening, Chair Craven and honorable committee members. My name is Raquel Baker, and I am here in strong support of Bill 6161. My name is Raquel Baker. I am 32 years old. I have lived in Rhode Island my whole life. When I was 19, my head went through the driver's side window of a truck, and I was dead on scene. Thank God, after 2 weeks, I was able to breathe on my own and woke from my coma. I have a traumatic brain injury, and I'm handicapped on the left side of my body. I went to jail February of 2021, and while I was there, a girl lied, saying that I put my hands on her. And without investigating it, I was put into solitary confinement. I told them I had a TBI and couldn't handle being in that room, but they didn't care. I nearly lost my mind inside solitary confinement, and I was only there for 3 or 4 days. I couldn't breathe and had multiple panic attacks while I was in there, but nobody cared and no one helped. I was walking in circles and looking at the blood on the walls and floor. I contemplated smashing my head on the wall, but thankfully I was let out before I actually went through with that. Solitary confinement is torture. No one should ever be in that place. I am begging you to please put an end to solitary confinement because I know I'm not the only person with mental or health issues that has gone there.
Thank you very much. Next.
Good evening again. I'm Natalia Friedland. I'm an attorney with the Rhode Island Center for Justice, and I have a couple of brief remarks about 5149, the Life Without Parole bill, and specifically to expand on what Representative Edwards said about the parole board and their experience in dealing with these issues. And the parole board's been around since 1915, over 100 years. They have 100 years of experience evaluating prisoners' applications for parole. They have a comprehensive and well-developed statutory, regulatory, and judicial framework that they use to consider applications for parole. And they routinely consider parole applications from people convicted of murder, multiple consecutive sentences, and really serious convictions. One of the things that I would encourage anyone who's interested to look at is the parole board meetings are actually subject to the Open Meetings Act, and their minutes are all posted online. If you go to the Open Meetings Act's website, you can see about twice a week all year, very detailed notes about every single person who went up for parole, redacted, the decision-making that went into each decision, whether they were paroled, whether they were denied, parole revoked, and so on. And so, as recently as March 3rd, the parole board heard someone who came in. He's serving a life sentence for murder. He was represented by an attorney. There's about a full page of small text of all of the things that the parole board reviewed, letters for and against, letters from victims, the institutional record, the criminal history. There were presentations by himself, presentations by his attorney. He was unanimously denied release because of the seriousness of his offense, and the next date was scheduled 5 years out. The last 2 hearings that are up there, there were 24 people who went up for parole. There were 4 grants. They were all from minimum security. Everyone else was denied or revoked. And just to say that the parole board has extensive experience dealing with these issues, and they're not afraid to say no. In particular, concerns that people have that the parole board would just be routinely granting these things in spite of the seriousness of offense. That is one of the factors that the parole board is statutorily required to consider, and there's actually a 2016 case from the Superior Court which says that the parole board is clearly statutorily prescribed from granting a parole request in the event, this is the last thing, that release would depreciate the seriousness of the offense or promote disrespect for the law. There are multiple aggravating factors, mitigating factors that they can consider to deviate. They're extremely experienced in this. This would not be a blanket release of people. This would give them a chance to appear before a board that is extremely professional, that has a lot of experience doing this. Thank you.
Thank you. Next.
Amen.
Good evening. My name is Maureen Moranci. I'm here on behalf of my son, Stephen, who is incarcerated and has life without parole. And I'm here to see if we can end life without parole and have the inmates get a chance to go to the parole board to be heard, because I do know that people can change, and I've seen it with my son. My son has studied hard, and he's tried so much to help other people. I mean, he's not just sitting back doing nothing. He's helping other inmates that come into the prison, and he's making sure that he can try to change their life around as well. So therefore, I just want to let you know that I feel that people can change, and I want to let you know, even though my son may not be able to come out, please have other people get a chance so that they can be heard. And I'm proud of the man he became today. Okay, he called me before I came here just to give me moral support so that he knows I might have strength to be able to do this, because it is hard for me to speak, because that's the type of person I am. Thank you for hearing me.
Thank you very much for your moving testimony. Okay, so now, who has not testified yet in the room? Oh, my goodness. Okay.
Thank you guys so
Bye, thank you. All right, you three in the middle want to come up?
She's
I
going to
have
come.
to go.
Okay, all right.
I've been here forever.
You two want to come up, the two of you? Oh.
Pat, you want to testify
You
as soon
got
as
to
you can?
keep 2
Okay.
minutes. We have to stick with the 2 minutes. We have piles of it. We have piles of them.
We would be here till 3 in the morning if we did that. There's 16 lists with 400 or 500 names, many of which aren't here anymore, have already testified. If we went through each one and called it, we would take more time than just simply calling people forward.
Who wants to start? You want to start? You want to start?
I'll start. Thank you to the committee. My name is Clara Hardy. I'm a licensed social worker. I'm here to testify in support of 2 bills. Actually, the first bill is my former opponent, who's not here, Corvasi. I actually support one of his bills, and that's Bill 5209. I have a written text message from somebody that wanted to come but couldn't come. He was at the time working. He's probably asleep now. Being a felon is very hard to get a job. There are a lot of people that are incarcerated, come out and want to work, but can't because the system allows those who want to hire us and can't. And the majority of the time, people just look at felons as, I don't want that person working here because they might steal. But if they couldn't do the criminal background, then things would be different, and then we would have more. That is from a client's husband that I work with. I also I wanted to just read a quote. Oops, hold on. Trying to get this. In 1937, Franklin D. Roosevelt said, "The test of our progress is not whether we add more to the abundance of those who have much. It is whether we provide enough for those that have too little." And I believe that as a lot of us here are very privileged, we have the resources, we have the social networks, but some are not, and we need to give them a chance to seize opportunities that they otherwise might not have. I'm also here to testify in support of Representative Cruz's bill. That's House Bill 5686. That's the parent caregiver bill. As a social worker, I too often see families torn apart mainly by DCYF, another dysfunctional organization that is poorly managed. But just like DCYF, the criminal justice system has a way of harming families through unnecessary incarceration of caregivers who should be penalized by alternative methods. I will address the impact this has on children who I am most familiar with. It is very clear that children...
It's time to wrap it up, please.
Are traumatized when a caregiver is incarcerated. The Adverse Childhood Experiences Index, which I use with many people, one of the indicators is a parent caregiver who has been incarcerated. A high score on this index indicates poor outcomes in health and social well-being as a person gets older.
Thank you.
And
okay, Mike, you're next. 2 minutes.
So I can testify on my 3 bills in 2 minutes.
Okay.
6139, Representative Casimiro's Second Look Act. The folks who testified before me addressed all of my issues far more eloquently than I can. I just have two technical things to point out for the record, and I hope my friend John Manny is writing this down.
He is.
Number one, it's very important, if you enact this, to avoid separation of powers issues, make sure the court has a very robust role in performing its functions. I saw it as a lot of steps in it. Add some more. Give them plenty to do. That way you avoid separation of powers, number one. Number two, very strong language is needed on the question of jurisdiction. Why do you ask? Because the Rhode Island Supreme Court has put in place a 120-day time limit on revisiting sentences. And it's jurisdictional, meaning it can never be waived. So if you're going to do this, do it, amend the jurisdictional statute. I got language in my head. I'll share it with Mr. Manny or anybody else who's interested.
Great.
5562, Department of Corrections, good time bill. We support that. We appreciate Acting Director Salisbury reaching out to the Criminal Defense Bar and getting our thoughts. You'll see there's a letter from the Rhode Island Association of Criminal Defense Lawyers. Appreciate the fact that he reached out to us through Ryan Crowley. We support that. It's a big improvement over where we were a number of years ago when the Michael Woodmansee case came to light. I don't want to talk about that, but you know what I'm talking about.
Yep.
You got to do something, right, to get good time credit. That's what this bill does. Lastly, Representative Felix's bill, 5697, technical in nature, restores the original version of a ceiling bill that you enacted last year at the request of the judiciary, Judge LaFazia, and the public defender. Boy, there's three strange bedfellows right there. But we agreed to this. We agreed to this language. The AG didn't. We came in. We had to put in a sub-A at the end. Now, it's all topsy-turvy.
Okay, Mike.
The judiciary objects. The AG has said nothing. I don't know what else to say.
Thank you very much. Next.
Thank you. I'm honored to be here. My name is Carl Kruger. I'm an immigration attorney, and I'm here to speak in behalf of 5361. This is the bill that would adjust the misdemeanor definition by the 1 day. This is hugely important because of the way the immigration laws are set up. The consequences for non-citizens who are convicted of crimes is incredibly harsh. Not only can individuals be deprived of getting lawful permanent resident status here, but it's also the most common way that individuals are stripped of their resident status and deported, is if they're convicted of certain types of crimes. The immigration law stacks the deck. The immigration law already ignores much of state law as it regards criminal matters. For example, immigration law has its own definition of what constitutes a conviction. A Rhode Island filing that is pursuant to a NOLO plea that's coupled with a court cost assessment would be a conviction for immigration purposes, regardless of how Rhode Island defines that. Immigration law has its own definition of sentencing. Any time, suspended or otherwise, counts. So someone who gets a 1-year suspended sentence has a 1-year sentence. They give no weight to expungements, absolutely none. They will give weight to vacatures only if they're done for very explicit reasons. The point is that what immigration law has done over the last few decades is moved the line. Traditionally, there's a distinction between harsh crimes, felonies, and less egregious crimes, misdemeanors. And that line has always been you can be punished by up to a year for a misdemeanor. Anything for which you can be punished by over a year is a felony. Perfectly reasonable. However, immigration law straddles that line on the other side. Immigration law consequences follow if you're convicted of a crime for which the maximum punishment is 1 year or longer, which sweeps all misdemeanors into that category. Similarly, immigration law harshly punishes individuals who've been convicted of crimes and have been sentenced to 1 year or longer. Again, sweeping misdemeanors into that harsh category. So this is a very simple law, and it's really not doing an end run around the immigration law. It's rather establishing or reestablishing the line where it should be. which is this bright line between harsh crimes for which people should be deported and less serious crimes that such a harsh consequence should not result.
Thank you very much. Next, we're going to bring you three ladies. Yes.
You're the next group.
Okay, who wants to start?
I would ask that you allow my cousin to try and finish, and if it takes up the three of our time, then it be. But we just feel it's really important that one person at least get to give their full
Okay.
testimony. We've
All
been
right.
here for 9 hours. Thank you.
Great.
Dear honorable members of the committee, of the House Committee on the Judiciary, thank you for allowing me to testify in opposition of H5149, which will abolish life without parole. I'd like to begin with a quote from a Providence Journal article published on July 4th, 2008, from then Attorney General Patrick Lynch, who stated, "She suffered one of the most barbaric and violent sexual assaults possible before her tormentor, someone she had considered a friend, killed her. This demented sexual predator who took advantage of Anderson and horribly and fatally brutalized her will never be free again. On behalf of keeping our community safe from a sadistic killer like this defendant, I thank the jury for affirming that Anderson's death was consistent with aggravated battery, and I appreciate Judge Gaylor's ruling yesterday ensuring that the murderer never has a chance of regaining his freedom. These words gave us some closure, and now we are living in hell all over again. Are you truly willing to vote in favor of this bill today and disturb the jury and judge's ruling? Are you going to break the promise to Kelly, my family, and the Rhode Island community? On behalf of my aunt, Kelly Anderson, and family, I am here today fighting to keep justice we received 15 years ago. In the last few weeks, by hearing a proposal of this bill, our family has endured unnecessary fear, pain, and sorrow by being forced to relive the most brutal events that led to the violent death of our beautiful Kelly. You have torn open wounds of our family after we were promised it was finally over. Our family has questioned your motives for this bill because a sentence of life without parole is not given lightly, for there are over 30 murders a year in Rhode Island, yet only 31 have been given this sentence. The monster was already on parole from a second victim, who then tortured and murdered a young mother on June 28, 2006, named Kelly Anderson. For years, our family could not move on because we had to anticipate and be ready for trial. And I pray for the justice that Kelly so desperately deserved. I can't possibly begin to describe how dark those years were, especially for Kelly's children. Although we would finally get the justice she deserved and some sort of peace knowing he would die in prison and not be able to harm another soul, our lives would never be the same. Brian Milnick was convicted of first-degree murder of Kelly Anderson by strangulation after he bound her with a television cable against her will, sexually assaulted, and tortured her for more than 6 hours. On July 3, 2008, a jury found the defendant guilty of first-degree murder in violation. The jury later found that their murder involved aggravated battery, which is also known as torture. During the 3-week-long trial, the judge ordered my Aunt Kelly's children to leave the hearing. My mother, who is the sister of Kelly Anderson, ordered the same for me and other cousins to leave while the medical examiner spoke of the horror she endured while displaying the most graphic pictures seen in a courtroom. And preparing for today's testimony, Kelly's daughter and I had to read that most graphic, heinous details for the first time. To say my aunt was murdered by strangulation truly does not begin to describe the suffering she endured. I think it's important for Rep. Edwards and the other sponsors of this bill to know the full details of the evil they advocate for. I warn you at this time you will hear extremely graphic details, and I ask that you listen carefully and ask yourself if this evil deserves a fourth chance or deserves to have hope of being released one day. And I will keep this shorter than I had submitted due to the time constraint, but I ask that you allow me to finish. The medical examiner described in detail that every part of Kelly's body, from head to toe, inflicted bruises and injuries, some during postmortem. Dr. Giuseppe, the medical examiner for the state of Rhode Island, conducted an autopsy of Ms. Anderson on June 24, 2006. Dr. Giuseppe noted that it would have taken a fairly large object or a large amount of force to produce some of the larger bruises. He further testified that he discovered multiple traumatic injuries on the top, the back, both sides of Miss Anderson's head, consisting of extensive bruising and areas of hemorrhage. Near the anus, there was a large purple-colored contusion and a large and small laceration. On the perineum, there was a laceration approximately 1 inch in length, and on the vagina, there were multiple lacerations, some 1.5 in length. These injuries would have required surgical repair. He mutilated her. Dr. Giuseppe explained that it was unlikely that fingers could have caused these injuries, but noted a fist could have. Finally, Dr. Giuseppe examined Ms. Anderson's neck, and an exterior examination revealed 2 contusions and faint parallel linear impressions on the neck. An external examination revealed multiple areas of hemorrhage with multiple muscles of the neck and fractured hyoid bone. Dr. Giuseppe testified that these injuries were caused by strangulation, and he stated that Ms. Anderson had died from strangulation. He explained that causing such strangulation took a large amount of force, likely somewhere between 4 and 11 pounds of pressure, applied for at least 3 to 4 minutes. He estimated that Ms. Anderson had died midnight around 3 a.m. The Rhode Island criminal system has worked for Kelly Anderson, for we received justice, and the monster responsible received the appropriate sentence of life without the possibility of parole. Furthermore, as our law states, he was able to appeal to have his sentence reduced, in which all those appeals concluded the sentence given was appropriate. Life without the possibility of parole was appropriate. One of the appeals wrote, "We feel it is appropriate to include in our decision today the particular telling words of the trial justice explaining his conclusion that defendant merited the most extreme penalty allowed under Rhode Island law. I agree wholeheartedly with the jury's finding that this murder was committed in the manner involving aggravated battery." And they chose their basis for an imposition of a sentence of life imprisonment without parole was involved in the first-degree murder of which the defendant has been convicted. The court stated, and I find in the jury, I'm sure, found that the defendant disabled the victim beyond what she was already feeling due to the ingestion of illicit drugs and perhaps prescription drugs. He plied her with alcohol. He at some point began to beat her all over her body, and that did not happen in a few seconds or a few minutes. The exhibits were introduced during trial that were some of the most graphic I have ever seen. The photograph showed how savagely Miss Anderson was beaten. This did not occur by a fall in the bathroom or 2 falls in the bathroom or 5 falls in the bathroom. More than likely, 2 falls. More than likely, Miss Anderson was beaten while she was bound by wire cable. What makes this court believe beyond a shadow of a doubt that she was bound without her consent is the defendant's use of a television cable and Walkman wire earpiece cable to hogtie her. Miss Anderson was repeatedly, for an extensive period of time, sexually assaulted, both vaginally and anally, by the defendant using his fingers and fists. He explained to the police officers and the jury how that occurred, and I don't believe him. I think this was some bizarre, evil form of punishment the defendant was given to the victim. Had she survived, she would have required surgical reconstruction of her vagina and anus. They were badly mutilated. Finally, he strangled Miss Anderson to death. Based upon the evidence primarily from Dr. Giuseppe, the medical examiner, I found to be highly credible, the strangulation which occurred here involving the fracture didn't occur in just a few seconds for death to result as it did. There was substantial force which, after 30 seconds, generally results in unconsciousness of the victim, but death does not occur for 3 to 4 more minutes. So the defendant applied deathly pressure to the neck for a substantial amount of time, demonstrating his clear intent to kill her. For reasons we will never know for sure, the defendant then placed Miss Anderson in a bathtub of water. He must have known by that time that he had likely succeeded in his goal because he had submerged the entire body, including her head, underwater, and there were no bubbles. Thus, this horrific incident lasting over perhaps 6 hours is clearly a case of murder by battery. I find that this defendant acted in the most violent and depraved manner. He has a history of this. This court remembers vividly the testimony by the North Kingston victim, which I felt was powerful and truthful and chillingly similar in its detail as to what occurred here. In the North Kingston case, the defendant disabled the victim with their drugs and alcohol. When she passed out, he bound her against her will and without her consent and kept her bound despite her protestations that she wished to be released. He beat her face much to her shock. He violated her repeatedly, anally with his fingers and his fist. I felt during the trial, and I feel for purposes of sentencing, that this prior conduct is very significant. It was a death that, quite frankly, I don't understand, but I have no doubt that it was a murder in the first degree and committed by aggravated battery. Totally senseless, this defendant, under certain circumstances, snapped. He snapped here, he snapped in the North Kingston 6 years before. I find, despite his protestations to the contrary, that he lacks any true remorse. He does not exhibit responsibility for any of his conduct, let alone the murder, as he exhibited in this case by his savage beating and strangulation of Miss Anderson. I find this defendant has the truly evil side to his persona. I find there is virtually no likelihood that defendant can be rehabilitated, never be made to feel safe. No counseling, no term of imprisonment will ever provide safety to society that it deserves from defendant, because I find him to be an extreme danger to our society. Here, the hearing justice gave due consideration to the trial justice's findings, quoting them at length, but nevertheless denied the motion, noting that it is too late for the defendant to change, as it is too late for the victim. The defendant had failed to acknowledge that his actions even resulted in the murder of Miss Anderson. The hearing justice was mindful of the brutal, senseless, and horrific nature of the defendant's crime, as well as the defendant's reluctance to bear full responsibility for the victim's murder. In our opinion, the hearing justice exercised his discretion appropriately, and his ruling should not be disturbed. We are not talking about accidental deaths or bad choices made in the heat of moment. We are talking exclusively about people convicted of first-degree murder and an intentional murder committed after deliberation. And I don't minimize any death. However, the murder of a family member who died in a stabbing or by a gun is totally different than a murder of someone who was tortured and suffered hours before dying. Murder in the first degree is completely different than murder in the second, and therefore should have and hold different sentences. As of now, the defendants have the privilege to speak and visit with their friends and families. They have the opportunity to have hope and second chances. Kelly Anderson does not. She will never see or speak to her children, her family, or meet her grandchildren. This bill will allow the defendant's fate of entering society on behalf of the same parole board who has failed Kelly and our family before. Had the parole board not paroled Brian Milnick for what he did to his second victim, the woman mentioned who resides in North Kingston, then Kelly would be alive today. Today you have the ability to end this nonsense of saving just one. I can guarantee you will not find one worth saving over the sake of protecting the community of Rhode Island, and it's not worth putting our families through this nightmare now or for the foreseeable future at every parole board hearing. This committee has the power to close these wounds for good and prevent this from happening to another person. If this bill is passed, you are promoting and encouraging lawlessness. If you decide to pass this bill, you are telling this community that you are promoting the release of people that rape, torture, and murder. Do not take this bill lightly. Your actions on this matter need to protect this community from these evil crimes. This is Kelly Anderson. A vote against this bill is a vote advocating for Kelly to keep justice. A vote of this bill is a vote in favor of this bill is a vote advocating for the most heinous criminals and murders like him a chance of freedom. It's that simple. And the reality is we do not live in a civilized country. Those who support and sponsor this bill all share in common that they have not experienced what our family has. Zero of this current bill should be changed. Thank you for the opportunity to share these details and provide insight to help you make your decision. I pray that you will all protect our community and vote against this bill.
Thank you. Thank you very much.
So that's,
Thank you for
I'm a whole different case.
She's another victim. Yes.
Yeah. I'm actually here to oppose as well for 5149. As I'm here representing and advocating for my family, friends, and Kristen George, as she no longer has a voice, as she's no longer alive. As I sit here today and think that anyone would be careless enough to think that a bill to eliminate the punishment of life without parole for capital offenses should be considered is astonishing to me. This would allow some 24 inmates at the ACI to be eligible for the possibility of early release. These are serious, violent criminals that committed heinous crimes. The bill is a clear message to all the families that have been affected by losing family members who clearly do not get a second chance in life because their first chance was taken away from them. This does not allow the families to heal and have justice served. I strongly disagree with the statement, life without the chance of parole is basically the second death penalty, as Representative J. Edwards stated. These prisoners are still breathing. They are still waking up and going to sleep. They have visitations and carry on with their lives, and they are supported physically and financially by taxpayers. The victims aren't breathing. They will never get another chance to open their eyes or to have visitors. They lost their chance on carrying on with their lives, allowing cases from 1991 forward to be eligible for potential early release is an absolute crime. Kristen George is my cousin. She was once a vibrant, beautiful, funny, young 16-year-old girl. She had a bright future ahead of her. Devastatingly, her life was ended by the hands of a violent criminal, and he was heinous, and it was premeditated murder. Previously, her murderer committed many crimes, and he is actually a habitual offender. He also had committed other violent acts to my cousin after he had murdered her. Those charges were dropped due to his life without parole sentencing. So he stabbed her 27 times, sliced her throat, and raped her, and wrapped her up in her blanket and stuffed her under her bed. My family has gone through a tragic experience that will stay with all of us for the rest of our lives. We will never get her back. She is missed and loved dearly. Not a day goes by that she is not thought of. For anyone to say that because these offenders are old and in there for life, they deserve a second chance, I would challenge any of you to put yourselves in my shoes or any of the shoes of my family members or loved ones who have had a life brutally taken from them, or better yet, to imagine that it was their daughter, son, cousin, niece, etc. How would you feel? How would you react? How would you sleep at night knowing that that family member's killer could be set free? Would you then become a prisoner, not knowing if you could leave your own home and be safe, in fear of knowing that they're free? If this bill should pass, it would be a neglectful way of saying that life is not valued and that it is okay to kill others because in America, we believe in supporting the guilty instead of the innocent. A pure injustice to our justice system and our nation.
Thank you very much for your compelling stories,
Gary,
all of you.
You want to testify on your bills?
I got a few bills, and I've already went one.
Yeah.
And,
This guy's coming over.
I want to make sure that you hear the testimonies of these individuals before you guys try to sneak out of here. So it's important that they.
All right, that's not fair. Now, come on, let's let people testify. We're not sneaking out. We're not sneaking out. All right.
Just sit in there. Just get in there. Yep. Pat's ready to go.
Well, all right. Sir, would you state your name and begin? Thank you. Is the red light on?
There it is.
Okay.
My name is James Montero. I am the founder and director of the Reentry Campus program, which Keith actually works for me. I'm also formerly incarcerated. I spent approximately 20 years of my life incarcerated up and down the East Coast. And I'm also the founder and president of Billy Taylor House, which is a program that helps youth in the Mount Hope neighborhood be able to have workforce development, enrichment opportunities with the goal of motivating them towards education and making sure they don't go down the same path that I did, because I was out in the street when I was 15 and I was incarcerated. When I was incarcerated, I remember I had did a score a long time ago when I was 17, $30,000. Went like that, gone in a minute. Thought it would last me forever because I thought it was just an enormous amount of money. And for some reason, when I was coming home at 40, I wished I would have had $10,000 of that money, because I know it's not a lot of money. And for some reason, I asked myself, whoa, wait a minute. What's the average age of a black man? Life expectancy. And it's approximately 80 years. And for some reason, I did the math, and 365 times 80 equals out to 29,500 days. And just like I realized that that $30,000 was not a lot of money, I realized that that 29,500 days that I may be fortunate to be given is not a lot of time. Maybe I might have 15,000 days left to do something and to make something of my life. My concept is, it's not what you acquire, accumulate, achieve in this lifetime that makes you great. It's more so, what are you going to leave behind? And a lot of these individuals that you see, I'm so happy, Cherie, everybody, because we've been doing this for a minute. And now what you don't realize is 30% of Rhode Island has a criminal conviction, with the highest concentration of that 30% in Providence, Pawtucket, Woonsocket, and Central Falls. And the reason why we have homelessness and employment problems and people can't afford to live here is because most of us have criminal convictions. And Galil Oliveira is one of my students. And I'm going to tell you that he is worthy of redemption. And that's pretty much all I have to say.
Thank you very much. Next.
Chair Craven, members of the board, my name is Stephen Matatol. I did 40 years in prison. I'm here to speak on Bill 6161. When I first went to jail in 1971, if you went to segregation, you did 30 days. On my second bid in jail, that increased, that was the Morris rules, 30 days, right? That was it. Then they come up with this B and C status, which after you did your 30 days, you go to a board, get a downgrade to do another 90, which was 120. Nowadays, it's up to 365. All right? If you had anybody with mental illness kill themselves back in the 70s when I came in, now you got 10 to 1, okay? Because they're doing 10 times the time they used to do. Now, I did approximately 5 years in all three of my bids in segregation. I was a law clerk. I read all the time. I was in multiple programs. I did 3 college programs. So I tried to keep my brain active. But I didn't come out of that unscathed either. I never got help for alcohol and drugs. And I didn't until I got out of prison. And when my mother died, I had to turn my life around. And kind of lost my train of thought. But anyway, while I was in prison in the 90s, there was a guy named Roger Bouillier. He had mental issues, and they chained Roger up with shackles and a black box. He was in the nude, and they chained the black box to his feet. Well, I left Roger my cosmetics when I got out of SEG. I don't know how long it was after that, because I went to meet him, but Roger Bouillier killed himself. And that's like I say, 30 days, 365 days. If he would have done that in the 70s, now they're asking for, what, 10 people to kill themselves? You know what I mean? That's serious business. 30 days is enough to teach anybody a lesson. I don't care what you did, you know? If not, you get out, you get another 30 days. You don't keep anybody in jail for a year, you know?
Well, thank you very much for your testimony.
Thank you.
Next.
I got to give Raquel a ride home.
Okay, bye-bye. Go ahead, next.
Hi, my name is Emily. Thank you, Chair
chairperson and the Honorable Committee for giving me the opportunity to testify in support of House Bill 5686. I'm a Master of Public Health student at Brown, and this moment means a lot to me because back in 2020, I was part of a cohort of students who took a public health course, and we interviewed experts, physicians, also people directly impacted by incarceration to look at what are their experiences navigating reentry. And specifically, I'd like to share about some of our findings on why this bill is good for individuals, families, and also for our state and the foster care system. First of all, what we found from our physician interview is that for parents who are primary caretakers who struggle with substance use disorders are more likely to relapse without the support of reunification. One of the key motivation for mothers to stay on track for recovery is if they're able to keep their baby after delivery. And when the child is removed from the mother by the state, their hope for recovery is being stripped away. I quote from another interviewee. It says, "The relapse rate goes up because the suffering continues. It's not just the addiction, it is the hopelessness and desperation they feel when they cannot see their kids." As some of you also know, that these caretakers who also have to be involved with the DCYF, which is a very confusing process to navigate in order to regain custody. And one of our interviewees spoke about how she was incarcerated when she was pregnant and has a 4-year-old kid who she wasn't able to see in an unsupervised visit until about 2 years later she got released, and how she observed a lot of behavioral issues as a result of a long-term separation in the child. And I want to also highlight that there are 12 states that have taken similar legislative action to provide caretakers with community-based sentencing alternatives. And particularly in Oregon, then an evaluation has been done on they call the Family Sentencing Alternative Pilot Program. And the outcomes are that those parents who were enrolled actually had a significantly shorter length of stay. Their kids have a significantly shorter length of stay in foster care compared to parents who were not enrolled in this program. And that the 3-year recidivism rate is also significantly lower among this group. And so I recommend that you review some of these facts, and I've printed out fact sheets and also report that a lot of students have spent years putting together, and I asked if I can distribute that to the committee.
Why don't you just give it to the clerk in the pink sweater?
Thank you very much.
Coral sweater over there. Okay.
There's 2 people over here.
Do you want to come up? Yeah, come on up. Oh. That girl was going to come up. Oh. We'll get you next.
Do you want me to dive right into it?
All right, 2 minutes, everybody.
In politics, we often hear the term dog whistles. Referring to the formerly incarcerated, even briefly, as inmates is a dog whistle. Anecdotally, questioning the honesty of an unnamed citizen is a dog whistle. In his testimony tonight, Richard Ferruccio acted and testified in his capacity as the head of the Rhode Island Brotherhood of Correctional Officers, representing the private interests of correctional officers. As such, his continued threats across multiple years and multiple committees to use proprietary confidential information of formerly incarcerated Rhode Islanders was highly inappropriate and worthy of sanction. Dignity and justice must overcome politics. The Brotherhood is a powerful union protecting the horrific practices that lead to the grotesquely excessive overtime realized by its membership. Their power must be blunted. My name is Pat Ford. I am the General Manager of the Coalition Radio Network, and I rise in support of legislation reforming solitary confinement. The state of Rhode Island is in direct violation of the United Nations Mandela rules, and as such is a torture state. From a statement issued by the Office of the United Nations High Commissioner for Human Rights, the Mandela rules provide states with detailed guidelines for protecting the rights of persons deprived of their liberty, from pretrial detainees to sentenced prisoners. The rules are based on an obligation to treat all prisoners with respect for their inherent dignity and value as human beings, and to prohibit torture and other forms of ill treatment. They offer detailed guidance as a wide variety of issues ranging from disciplinary measures to medical services. For example, they prohibit the reduction of a prisoner's food or water, as well as the use of instruments of restraint that are inherently degrading or painful, such as chains or irons. The rules restrict the use of solitary confinement as a measure of last resort to be used only in exceptional circumstances. Nelson Mandela found solitary confinement to be the most forbidding aspect of prison life. There was no end and no beginning. There's only one's mind which can begin to play tricks. I've testified before you before. As you know, I can go into extensive detail about Rhode Island's ongoing status as a torture state. I'll be reaching out to all of you at a more appropriate time in order to discuss the need to pass this legislation out of committee. It is well past time to end state-sanctioned torture. Thank you.
Thank you, Pat. I just want to say one thing. I see a lot of people have speeches. If you want to leave your typed testimony with the clerk, you can do that, and she'll post it online. And just tell us in your own words, so you can try to keep to the 2 minutes.
Sure.
Thank you.
I just have a couple bullets that I
Sure.
drafted to remind me. I'm here to testify in favor of 6161, the Act to Reform Solitary Confinement. There was a discussion of a spike in violence as a result of the implementation of HALT in the state of New York, which eliminated solitary confinement. But that's misleading because the violence that's occurring in New York prisons have been going on for years and years. So to connect them to the HALT Act is misleading. Also, if we had, and there are other ways to prevent violence. We could just hang people from the walls in chains, and then they definitely won't be violent. So where's the cutoff? In the 70s and 80s, the ACI was an extremely violent place, and solitary confinement was abused with abandon. So I still don't see the connection between the use of solitary confinement as a deterrent to violence. The idea, though, that a private individual would access private records of the DOC to the disciplinary records and the criminal records and submit them to this committee, and as that individual has done twice in the Senate, and accessing these privileged records for his private union activities, is amazing that that's allowed. And it's astounding. And my biggest concern, and the reason I'm here this late today as opposed to leaving earlier, is that I had a discussion with that individual today in the hallway of this chamber where he said, "Oh, yeah, I saw your testimony last in the Senate, and I found your phone number, and I found your address, and I looked at your house. What a nice house you have." Okay? This individual made that comment to me tonight in that hallway, and I feel threatened. And I feel scared now that someone has gone and looked at and described it to me. "Oh yeah, you have such a nice house. I noticed the white part in the background." And that's frightening.
Yes.
Okay, so this is something that I'm going to take up with the interim director, and I mentioned it to him, and I hope that this is registered by this panel, because it's abusive.
It is
And
disturbing.
it's threatening.
Yes.
And I'm a private individual. I'm here because I feel strongly about this as a voter. I don't represent any organization. And a gun toter told me that he knows my house and where I live today.
Well, thank you for your testimony.
Thank you.
I'm sorry.
Hi, my name is Alicia Liberty, and I'm here today on behalf of my sister Charlene Liberty, because she's no longer with us today. Charlene's depression turned into serious, persistent mental illness due to the inhumane treatment at the hands of the ACI. Being the lead case in a lawsuit against them by the ACLU, her experience was documented nothing short of torture. Charlene would attempt suicide because of isolation, go to the hospital for treatment for injury, only to return to isolation as a punishment for wanting to die from isolation. And the vicious cycle begins again. So I ask today who is going to care enough to break this vicious cycle. Charlene would be shackled in restraints and maced in the face in retaliation and frustration for hearing her cry. She would scream that she would want to die, and that would be her punishment. Charlene attempted suicide by hanging, mutilating herself, swallowing razor blades that she had surgically removed multiple times, and dove off sinks and toilets to break her own neck. Imagine diving off a sink to break your own neck. It's amazing. I went to the ACI, and I questioned the lieutenant there to ask her what was going on with my sister. She actually laughed at me. She said, "Who? Liberty? That wasn't even that serious." A medical staffer noted in her record that he was so overcome by pepper spray, he had to immediately leave her cell and come back with a mask on in order to re-enter, where he found her foaming at the mouth, bluish discoloration around her neck and face, and she was twitching like she was having a seizure. When she returned from intensive care, she was immediately placed back in solitary confinement. That was her punishment. She clearly didn't need any more isolation. Where was her much-needed psychiatric treatment that they talked about today that they do? Why would they spray mace in her face when it was clear that she was unconscious from hanging herself? No one in the Rhode Island Department of Corrections that was in charge of oversight can deny this was happening to her, because she filed multiple grievances, which is something else they talked about today. She was completely ignored. Leaving her feeling like the only option to get out of this was to die. They unquestionably need oversight, and not from them. So I ask again, who is going to step up and say enough is enough and protect all the people, including the ones that suffer at the hands of the ACI? Please
Thank
break
you
this
very
cycle.
much.
Thank you.
Okay. Reverend, do you want to come up? And, I was going to get this guy, because no, and Reverend's got to come up. The Reverend is coming up, so please. We already said to him that he could come up. He's been waiting. Been waiting a while.
Yeah, a long time. Good, Rep. Craven.
Why don't you start it off, Reverend?
Okay, I'll do that. A lot of people today talked about, and as a matter of fact, thank you very much for allowing me to speak to this honorable body. A lot of people talked about statistical information. They talked about several things that they like to do at the adult correctional institution, but nobody talked about outcomes. And whenever you got statistics, you have to have some sort of an outcome. So I'm going to give you an outcome. I wish I could do what Ron DeSantis did and load up everybody on the corner of Elmwood Avenue and Broad Street and drop them in your neighborhood. A lot of those people are damaged from being in segregation. And it's hardly anything that we can do, because you need a lot of support to address this problem. Somebody put a sign up right where we sing at, and we have a service at the corner of, right in front of the graveyard, and they put a sign up that says Riff Raff Way. And to me, that's the ultimate insult for this community. And I'm not going to take up too much of your time, because I think you very well know the condition on the corner of Elmwood and Broad. And all those people, most of them are formerly incarcerated. And a lot of them have spent time in segregation, and that is an outcome, a sad outcome of people who have been deteriorating. And I'm sure you don't want them in your neighborhood, but I would like to just load them all up and let you spend a couple of months with all these people. So that concludes what I have to say.
Thank you, Reverend. Next.
Good evening, Chairman and members of the committee.
and thank you for the opportunity to speak. I know it's been a long night. My name is Brianna Watson, and I'm here in support of Bill 5686, which would require courts to consider a person's status as a parent or caregiver before sentencing. So I'll keep my comments brief. Incarceration and separating families is an incredibly traumatic experience for both children and parents. There are numerous studies that have shown the impact of parental separation at all stages of children's development. My colleague who spoke just earlier shared some fact sheets with y'all, so I will let you review that. But I just want to emphasize the fact that children who have an incarcerated parent are at increased risk for a number of physical and mental health problems, behavioral issues, learning disabilities. They're at higher risk for foster care placement, abuse, homelessness, and involvement in the juvenile delinquency program. And all of these realities disproportionately impact Black and Latinx families who experience higher levels of policing, incarceration, and DCYF involvement in Rhode Island. Once parents are released from incarceration, I'm sure as you all know, they go back into the communities to face stigma and a number of barriers from obtaining housing and employment, substance use, services, and all of these severely limit their ability to not only reintegrate, but also to financially support their children and dependents. And overall, what I just want to say is I think that this bill is asking judges, but also all of us, to recognize the fact that incarceration doesn't affect just one individual. It affects their children, dependents, family members, and whole communities. And so I think there needs to be a more holistic, systematic approach that goes into making these decisions and ensuring that people are getting the support they need. Thank you.
Thank you very much. Next.
That was tough to follow up. Good morning, Honorable Committee. My name is...
Good morning,
I
that's
know,
right.
it's good morning.
It's good morning.
My name is Michael Sanchez Collins. I'm the younger brother of one of the incarcerated individuals that's currently serving life without parole. So I'm here in favor of obviously getting rid of it. Nothing really to add to this. I mean, you heard a lot of testimonies. My emotional story and my background is obviously I got to experience a different path. So my path, while he was on trial, I signed up to be a Marine. And currently, just recently, in the span of him being incarcerated, I retired from the Marine Corps. So just to put it in perspective, you know. So somebody said Jesus. I don't know why. But so just bringing those experiences and things that I've learned, obviously we understand that decisions you make as a young man, as a young individual, 18-year-olds can have lasting impacts. I've had Marines under my charge that have made, mistakes, and I'm all about rehabilitation. I'm all about reform because I've seen them change. I've actually served as a recruiter, and I've served as an instructor in a couple of my tours along my career. And getting to see the transformation from these young men and women mold and grow into something that, is contributing to society is like one of the most rewarding things you'll ever see. So if that could be bestowed upon us to see, a member do something, so egregious, so crazy, and then actually contribute to society afterwards, like you've heard testimony before, men, just incredible stories, I feel honored to be a part of it. I thank you all for your service, for putting up with us this morning. I have nothing further to say. I appreciate your time.
Thank you very much.
Thank you for your service, by the way.
Yes, thank you for your service. Purple shirt, you come up. I've watched you try to come up a few times. Okay, why don't you start?
Good morning. Thank you, Chairperson and members of the Judiciary Committee, and opportunity to support House Bill 5149. My name is Abraham Preciado, and I'm here respectfully for you to recognize the human capacity for change. And I ask you to provide hope to those people serving life without parole right here in Rhode Island. In 1997, I committed a crime, and I am mostly regretful for what I have done. There's nothing that I could do to change the actions of that day. What I can tell you is that I carry that regret and the remorse of that person I murdered that day. I was sentenced to life without parole, and I served 23 years and a half of that sentence. During that time, I did everything I could to change, to become humane, to show my remorse, and through my actions, I was able to do that. I remember the day I was sentenced, I was being walked through the hallway, and the officer screamed, "Dead man walking." I moved to the side, and he asked me, "What are you doing?" He said, "I'm talking about you. You're going to spend the rest of your life in prison, and you're never going to have hope to ever get out." At 18 years old, I did not know how to process that. I did not know what that meant. I know I wanted to cry. I didn't want other guys to see me crying. So I just held it in, and I just kept walking. But I knew I would never get out. At that moment, I had lost all hope. At that moment, I realized that I was just being sentenced to a different type of death penalty, and which was a slower death. I just didn't know what to do at that time no more. I had lost all hope. Life without parole, that's a crime that says that a person can never change. It says a person is irredeemable, and that we are, of course, the worst of society and monsters. My family, throughout my incarceration, visited me day and night whenever they could, and they themselves were also serving that same sentence. I know what it is like to be living but not live, to have empty dreams and clouded visions. I know what it is like to have a hope, but there is no hope yet. I pray no one continues to experience that slow death I experienced. I seen a book out there. It said the state of Rhode Island, I guess the Island Honor Roll of 1941 and 1945. And I seen an anchor on that, and in the anchor, it had hope.
Yes, that's it.
I'm asking you to give hope to those guys that are incarcerated, the men and women serving life without parole. In support of House
Yes.
Bill 5149, which will grant the opportunity for people to have that hope that I once had lost.
Thank you for
your time.
sharing. It's very nice. Next.
Hi, my name is Tyler Melwani. I'm a student at Brown University. Thank you, committee, so much for taking this time. I'm really tired. I'm sure y'all are too. So, thank you. So I'm supporting Bill H5686, which would allow courts to consider people's status as parents and caretakers before choosing whether to incarcerate them. And there are various reasons why I think this bill just makes a ton of sense. So first of all, in Rhode Island, 66% of women and 55% of men incarcerated at the ACI report having children. Children with an incarcerated parent are 7 times likelier to not complete high school. They are also at least twice as likely to have a learning disability or ADD, ADHD. Children with an incarcerating parent are over 3 times likelier to have behavioral problems or depression, and at least twice as likely to have anxiety. Children with an incarcerating parent are also 3 times likelier to develop an illicit drug use disorder during adulthood. Another big part of the bill that I feel like it might not be as obvious is the bill would actually make Rhode Island safer, even though in theory we're incarcerating less people. Because first of all, it can reduce recidivism rates among parents. A version of this bill was implemented in Washington state, and parents who participate in its diversion program have a 67% chance of lower recidivism rates. And the bill could also prevent children from committing crimes themselves. Children with incarcerating parents are 4.9 times likelier to have a felony charge, so it definitely helps to not have an incarcerated parent. And a parent's incarceration can cause children to enter the foster care system, which is a predictor of involvement in crime. So those are some reasons that show the bill could help families, children, and also reduce future crime, making our communities safer. I'd also like to quickly read 3 quotes.
Thank you very much.
No problem.
Time's up. Yes, sir.
Good evening, Honorable Chairperson and this committee. Thank you for hearing me. I'm a person who had a life sentence once, like some of the other people who testified today. And in my younger age, I committed a horrible crime that I will forever and deeply regret. And I feel it more so tonight after hearing some of the testimony here today. So if I can take a moment to say again, To everybody in this room, in this committee, and to my victims, I'm sorry for the crime I committed and the pain I caused. For 31 years, I served a life without parole sentence. I could look through the prison fence and see a world I would never touch again. I was living in my grave. That's what a life sentence feels like. I was living in my grave. When I went to prison, there were lifers there who came before me, who mentored me and inspired me to become the best self, the best version of myself. And decades later, I became that mentor as well. I'm here before you today because my state, the state I was incarcerated, passed similar legislation that you're considering today, and it allowed me a parole review before a board who carefully reviewed. Am I a threat to public safety anymore? Am I rehabilitated? Can I be safely released? And have I taken accountability for my actions? And 2.5 years ago, I was granted parole under parole supervision. Since then, I've held a job, I pay taxes. I serve as a public speaker to college and university students to talk about my crime, my redemption, release, and incarceration. I work with a local youth advocacy group to serve as a mentor to youth who have come in contact with the justice system. I do all that I can to give back to the community. And I would just like to point out that a life sentence takes away all hope. But as we've heard from other victims here today who have chosen a path for forgiveness and opportunity, it takes away all chance for forgiveness and redemption as well. And I just strongly ask you to consider what we've spoken about today, and I hope that you will support this bill. Thank you.
Thank you. Yeah, just let them come up, right? Come on up, 3 more. Musical chairs, let's keep moving, right?
Okay. Thanks for allowing me to speak. My name is Leonard Jefferson. I have a letter here written by Kenny, who is currently serving life without parole. He's 43 years old and has served 22 years. It's like 25 lines on this piece of paper. I think I can get it in within a 2-minute limit. In the community where I come from, addiction, violence, and poverty is normal. But even though I was raised in that environment, I never wanted to be a product of it. Unfortunately, I made very poor choices, and I was practically still a child when I came to prison. I haven't seen my mother face to face in over 5 years. Seeing her on video visits are good because I can see her, but it hurts because I can see her aging in real time. I feel shame because I put myself in a situation where I can't take care of her. Every morning that I wake up, I have the mindset to be optimistic considering the circumstances. Then I look around my 8x10 cage and realize that I've been stuck here for at least 22 years, serving a sentence that has no expiration date. I have a longing to be productive and to do positive things, but I'm not eligible to participate in most programs. It's scary to see guys who've been here so long grow old. In prison, you bond with certain people who become like a family, and when you see them deteriorate over the years and die in here, that's like watching an actual family member pass away. I know for a fact that I, too, will die. I just don't want it to be behind walls secured by razor wire in a prison cell. Receiving a death sentence without being subject to the electric chair, the gas chamber, lethal injection, or the firing squad is mental torture. When I think about the fact that I've been sentenced to death, but not scheduled to die, I wish that I had the death penalty because I wouldn't have to suffer emotionally and mentally. I've changed a lot since coming to prison, where I essentially grew up. I am a more humble man today, partly because the volunteers that I have met in prison. They take time out of their daily personal lives to come into a maximum security prison where people are considered to be the worst of the worst and to teach us all life skills. It's humbling because it shows that they see us for what we actually are, human beings, not animals.
Go ahead,
Good
ma'am.
morning.
Thank
you
you.
so much for taking the time and letting me speak. My name is Jackie Kennedy, and no, I'm not of the Camelot Kennedys. That was for my own breaking the ice. I'm a child of God. I'm a mother. I'm a daughter, and I'm also formerly incarcerated. During that time, I was in segregation, and that's what I'm here to talk about and why I support this bill. If you've never been locked up in a room by yourself, you have no idea what it's like. So I'm going to very briefly, quickly, and I might ramble because it's a lot to say in 2 minutes. After the first 72 hours, I really started, I can remember thinking, what have I done to myself? Why am I here? You get the same thing for breakfast every day. Day, night runs into each other. I can remember, and I'm sitting here doing it now, counting the tiles on the floor over and over again, hoping that they'd come up to a different number just to give my mind something to do. I can remember crying just to do something after the days run into each other, and you don't know what you're doing anymore. You start talking to yourself. That's just being in there. Never mind how you're treated. You know, we all have heard that saying, power corrupts. Not all prison guards are bad. We've heard testimony from both sides. Some are good, some go to work and want to help. Power corrupts. Absolute power corrupts absolutely. If you are at the mercy of someone else, and we all know human nature is good and bad, I can tell you horror story like other people can, but what I want to tell you is what happens afterwards when you are out and about in the world and have to deal with that. People can go in there for something as simple as shoplifting, as maybe disorderly conduct, and you spend time in segregation by yourself, or worse, with a stranger, and you have guards who torment you in many different ways, and you come out on the street and you're paranoid and you're dealing with PTSD, guess what? You find a drug to hide all that. Then you can't afford the drug. I'm a female. Guess what? You turn to ways to find money to get the drug. I sit here in front of you today in my right state of mind because of years and still in therapy. I still wake up and my fiance holds me because I think I'm back there. Like I said, sitting here waiting, I find myself looking around and counting these lines on the floor because my mind still goes back there. This is our society, people. This is what we do. Yes, I did something to get there. Yes, when I was there, I did something to put myself in that position. But come on, there got to be a better way than keeping someone locked up for 23 hours a day. I'm a mother. I've had to discipline my children. It never, ever occurred to me to keep them locked up for 23 hours a day, no matter what they did. And I had some bad kids. I've taken puppies home, and they peed on my floor. I still didn't keep them locked in their kennels for 23 hours a day. There got to be a better way. We got to, as a society, come up with a better way. I appreciate your time. Thank you.
Thank you, Jackie. Yes, sir.
Yes, I'm fine. I'm here to talk about the solitary confinement. My name is Tyrone Shaw. I'm an ex-convict myself. I was doing life on an installment plan, 2 years, 18 months, 3.5 years. Then I caught a life bid. In regards to the life bid, I was in and out of solitary confinement. And that's what made me think. Education is the key to freedom. So I got my education while I was in segregation. I got out of segregation. All right, I'm going to piggyback off what the institution said. They give you blankets when it's cold, but yet the blankets they gave you, 2 months after they gave them to you, they're going to come and book you and put you back in segregation for having excess belongings. But that's all irrelevant. In regards to me getting my education, I was in and out of seg. It took me 32 tries to get my GED, and I finally got out of seg and got it. And since I've been out, now the parole board
didn't want to give me parole. I was doing life. They wanted me to take responsibility for the crime I was in.